on time, but I see some stragglers out there, and with parking and finding your way around and all that, I expect people to come in as we go. So my name is Walter Cox. I'm an attorney with Nelson, Mullins, Raleigh, and Scarborough, which is a firm located in South Carolina, North Carolina, and Georgia, as well as a small office in Washington, D.C. And I have had the pleasure of being affiliated with Duke University School of Law since 1999 as a result of the invitation of Judge Robinson Everett to come help him teach some criminal law courses. And this semester we are teaching a course called Advanced Issues in Criminal Justice. It's a 2-hour course, and this is a key piece of that course, and our students are participating with us today, and they're getting the wonderful opportunity throughout the semester to meet some very nice people in the bar who are teaching them things about criminal justice you don't learn out of textbooks. Before we get started, however, and before I introduce Judge Everett to you, I'd like to turn the program over to Dean Kate Bartlett, and she's going to welcome you to this institution. So, Dean Bartlett.
Well, I have a very small role, and that is to welcome you to Duke Law School. I see some familiar faces out there and some not so familiar faces. Please, I hope while you're here you get a chance to walk around the building. There are quite a number of new changes. Those of you who are Duke graduates will be familiar with a whole new look on the front of the building, and a couple of classrooms, including this one, renovated this summer. And then what's going on out here, I hope you won't be distracted by it this afternoon, but we're having a 25,000 square foot 25,000 square foot addition put on there for our legal clinics and law journals and faculty offices and interdisciplinary center offices. So we're real excited about that. And eventually, that outdoor courtyard that you see that's really, literally will be in the center of all of our operations will be enclosed in a nice indoor atrium, and we hope that will become the real hub, intellectual and social, of the law school, and we're really, really excited about having that work done as well. So that's into the future. When you come back here next year for this conference, maybe you'll see some progress toward that goal. I'm very happy to have this conference here. I want to thank Nelson Mullins for sponsoring it, and Judge Cox. It's always great to see you around. The more the better. He's done an awful lot has many fans at Duke Law School, both students and faculty, for all of his many contributions to our curriculum. I'm so pleased that this is in honor of I never know whether to say professor or judge, but our good friend Robinson Everett. I was at an event last night where he was given the Professionalism Award by the State Bar, and it's just one of a long string of very well-deserved awards. We're so proud to have him on our faculty. We're so, I know a lot of students who have had him as their criminal law or criminal procedure professors are very proud every time they see his name in the news or see him honored by a bar association or what have you. So I will stop there. I am not a substantive speaker. I'm just here to welcome you. It's great to have all of you here, and please enjoy. If there's anything that you need, let us know. Thanks.
When we decided to do the seminar, I was given the pleasure of naming it, and I wanted to name it after my colleague and friend Robinson O. Everett. Some of you, maybe all of you, know Judge Everett, and I came to know him almost, just 20 years and about a month ago when I joined the United States Court of Military Appeals, as it was known as, in 1984. It later, under the leadership of Chief Judge Eugene Sullivan, who is with us today, became known as the United States Court of Appeals for the Armed Forces, a name that more aptly describes exactly what that court does. But in 1984, Robinson Everett was the chief judge of the court, and he served as chief judge from 1980 to 1990, when he retired, or took senior status, I guess, and came back to teach here at Duke University full-time and to practice law in North Carolina. He's an extraordinarily amazing person. 20 years ago, not only did we enjoy traveling together, we enjoyed playing tennis together, basketball together, and many other things. And in 1999, when my term on the Court of Appeals for the Armed Forces was coming to an end, he asked me to come down and serve as a fellow, a senior lecturing fellow, and lecture on military law. And when I said I'd be delighted to do that, I thought I was coming down for 2 hours. When I got here, he says, by the way, I've got a couple of other courses I want you to help me teach too. And one of them was this course on advanced issues in criminal justice. Robbie, I think you've been teaching at Duke over 50 years now, haven't you, on and off?
I think it's about 47.
47? 48?
Lost count.
But he still teaches an early morning class in basic criminal law. It's a 5-hour course, and I've co-taught it with him over the years. It's a great course. I think it's one of the, and he and I both truly believe that the criminal law, that you have to understand that to be an attorney for a lot of reasons. One of it is human relations is the basis of all law. And while most of you, I think, probably do not practice criminal law, we decided to put on a seminar for people who are in the practice of law who don't practice criminal law but would like to be in a position to recognize a lot of the issues, particularly in this new era, really, of white-collar crimes. And we've assembled a wonderful faculty here today. Judge Everett, would you like to welcome this group? I'll give you the floor if you don't take it too long.
I think all I can do is say thank you for this honor, and it's a real privilege to be here with you and to have you here. I think it's going to be very meaningful, and I'll enjoy chatting with you later on, either after the program or otherwise. Yeah. Thank you very much, and I'm very grateful.
Yeah. A couple of, every seminar has some administrative announcements, a couple of quick ones. If you need to use restrooms, the closest ones and best ones are when you leave, go out to the right all the way over. The ladies' room is to this side of the steps, and the men's room's kind of back in the corner off to your right when you leave this room. Following the seminar this afternoon in the Birdman Lounge, which is the faculty lounge, which is down the corridor on this third floor and around to the right, we're going to have a reception in honor of Judge Everett, and so you'll get a chance to meet and greet the speakers and Judge Everett. And those of you who want to get CLE credit, this course has been approved by the North Carolina Bar Continuing Legal Education Group, whatever the official name of it is, for 4 hours of CLE, 3 hours of ethics. You will need to pay a fee. There's a $9.75 fee or something like that I have to send in. So I just ran it off to $10 to help cover the postage and stuff. So I hope if you want your money back, I'll be glad to refund it, but I don't think that's too much. I'm going to turn the program over now to our first speakers. The Honorable Carl Horn III is the Federal Magistrate Judge in Charlotte for the Western District of North Carolina. I consider him the Dean of Continuing Legal Education in criminal law in the state of North Carolina. He's recognized for his writings and for his teachings. He also has done a wonderful book recently on professional responsibility that I not only have had the pleasure of reading, but asked my firm to spread it throughout the firm. I don't know if we ever bought any more or not, Judge Horn, but it's a great book and I commend it. And speaking with him is Mr. Peter Anderson. So I'm going to turn it over to Judge Horn to introduce Pete and his program. Judge Horn? Robbie, you want to sit, you want to move out, or you want to stay out? I think it'll be easier for us to move. Whatever you'd like to do. Get my water.
Well, good afternoon. Thank you, Walter, for those very kind and exaggerated words. My friend Pete Anderson and I have a formidable task. That is to address the subject of federal white-collar crime in 1 hour. So I will begin with a caveat. Due to the obvious depth and breadth of our assignment, we will necessarily only be scratching the surface. In many instances, merely mentioning issues or subtopics which themselves could be the topics or the focus of an entire seminar. During my almost 18 years in the federal criminal system, the first 6 as a prosecutor and supervisor of prosecutors, and now almost 12 years as a judge, I've witnessed immense changes. And frankly, while the bipartisan political motivations behind these changes have been, generally speaking, well intended, the results are mixed at best. First, there has been what some call the federalization of criminal law, including but certainly not limited to the prosecution of white-collar crime. This has occurred essentially in 2 ways. Most obviously through new laws being adopted. Criminal statutes governing health care fraud, identity theft, and computer-related offenses are several examples which come to mind. But more than new laws, federalization has resulted from a geometric increase in federal resources committed to criminal enforcement, and ipso facto in the number of inmates serving ever longer average sentences, complements of the United States Department of Justice and the United States Bureau of Prisons, and of course, the U.S. taxpayer. Now, as an aside, although not an unimportant one, when we calculate the costs of prosecution and incarceration, we should not forget to include income which will not be earned or spent, state and federal income taxes that will not be paid, and even the reduction in restitution that victims are likely to receive. This is not to say that white-collar defendants should get a pass on imprisonment, but these are real societal costs as a matter of fact, and they should be factors a wiser sentencing system left to the district judge to consider on a case-by-case basis. During these years, the expansion of federal criminal law has also been accomplished in a more subtle way by a reduction in what is required to prove intent. Whereas proof that a crime was committed knowingly used to mean just that, increasingly juries are being instructed that the standard is knew or should have known, or even that a defendant may be found guilty if he, she, or it, in the case of a company, was willfully blind. Furthermore, the object of this constructive knowledge or willful blindness, which perhaps was a subject of civil regulatory attention. Am I still on? Yes. Which was perhaps a subject of civil regulatory attention 20 years ago, is now felony misconduct being afforded priority federal attention and backed by severe penalties. That is, by heavy fines, and where individuals are charged by mandatory and sometimes lengthy terms of imprisonment. The other, perhaps even more significant change in the past 15 to 20 years has been the adoption and application of the United States sentencing guidelines, which have taken most of the sentencing discretion from federal judges and effectively given it to prosecutors. Again, while the bipartisan impulses behind the adoption of standardized sentencing guidelines were understandable and substantially benevolent, many involved in the federal criminal system are now questioning the wisdom of taking discretion, say, from Judge Mack Howard, a federal district judge who will be speaking to you this afternoon, and giving it to his very fine son, a federal prosecutor in Charlotte, Josh Howard, who will also be speaking this afternoon. Federal white-collar crimes are created and governed by a broad array of statutes. In addition to the several areas already mentioned, for example, they include laws proscribing mail and wire fraud, bank and mortgage fraud, securities fraud, false claims, tax-related offenses, bankruptcy fraud, environmental crimes, antitrust offenses, OSHA violations, criminal statutes pertaining to food and drugs and consumer products, money laundering, and even certain business crimes charged as racketeering. And this is but a very partial list. Nor must we forget what might be called investigative process crimes. Much like a company sued civilly for employment discrimination, which did not discriminate but improperly retaliates against an employee for reporting that it did, an individual may be exonerated of the substantive white-collar crime being investigated or charged, but successfully prosecuted for making false statements, intimidating witnesses, or otherwise obstructing justice during the investigation. And finally, by way of introduction or stage setting, a brief word about the importance of compliance programs in today's federal criminal culture. Federal white-collar crime is definitely an area, as the old axiom goes, where an ounce of prevention is worth a pound of cure. As I think Mr. Anderson will emphasize, this is clearly borne out in the experiences of the best and the brightest in the federal criminal defense bar, those lawyers who regularly counsel companies and white-collar clients not only once they become targets or defendants, but also on how to stay out of a prosecutor's sights altogether. It is also clearly reflected in what is known as the Thompson Memorandum, a document that guides federal prosecutors in deciding whether and whom to charge in white-collar criminal cases, and in the United States sentencing guidelines, which were recently amended again to reduce or enhance sentences based in large part on compliance-related considerations. Well, that's all the surface scratching I should probably do, since I am only eating into the time of my co-presenter, who knows far more about our subject than I do. Peter Crane Anderson, also known as Pete, is a graduate of Rutgers University and the University of Virginia Law School. His legal career has been rich and varied. Following his clerkship for our Chief District Judge, Graham Mullins, a Duke Law graduate and member of your Board of Visitors, as was my dad, Pete was accepted into the Attorney General's Honors Program, where he served for several years in the Justice Department's Environmental Crimes section. After a stint as a federal prosecutor, who I had the pleasure of supervising, he still refers to himself as a recovering prosecutor. Pete has been a partner at Hutton & Williams and most recently with the Charlotte office of Shumaker, Loop, and Kendrick, where he heads his firm's corporate compliance and business crimes defense team. Pete, please come take us to the end of our hour.
Judge Horn, thank you so much, and thank you everyone else who's been a part of assembling what looks to be a very interesting day. I appreciate the opportunity to be here. I did get a call, though, from the Dean of UVA when he found out that I was actually going to be speaking, and he promised that my firstborn could actually come here for free if I just put this on, so I'm just going to basically slide it over. I've checked the box, and now I can actually, I can report back that I've done my Wahoo duty. So it's a pleasure to be here. We are a little bit constrained on time. Hopefully everyone can see that. The handout does cover the topics, 6 to a sheet, so I'll dive in. When I first thought about the challenge with Judge Horn to cover in 45 minutes or less something of interest without kind of getting into boring minutia, I thought back to my experience over the last 15 years on what I've been able to observe that was in play even before that, and I've called this basically the perfect prosecutorial storm, a convergence of forces as well as some recommended responses. And again, this is one former prosecutor's viewpoint. I should say, like the Department of Justice in reverse, my comments do not represent those of all of the defense bar. So let me go ahead and dive in. Again, I believe I provide somewhat of a unique perspective because I am a recovering prosecutor. It's a 12-step program, and since I've been out 8 years, I guess I'm on step 8. But similar to I guess it's the Sondheim song about clouds, I've looked at life from both sides now. And it's very helpful and interesting to be able to look back at the perspective, and it helps me as a practitioner to appreciate how this area of law has developed and continues to develop. My goal in private practice over the last 8 years is really to help clients sail through this prosecutorial storm, as well as to teach lessons without slamming jail cell doors. Obviously, the modern, I say modern, I mean today's criminal defense attorney is facing incredible challenges both in the law as well as resources and some constraints on balance with the Department of Justice. But there's also some amazing opportunities, and it really is a calling. Those of my brethren in the defense bar really are up against some pretty formidable forces, and it could not be a more rewarding time to be in the federal criminal arena. But there are obviously a broad range of necessary skills that you need to use. One area that I found would have been of interest to me now, had I taken it, for white-collar criminal defense is anthropology. And it might strike you as it has no application whatsoever, but the definition is the scientific study of the origin, culture, and development of humans. And so the notion of when you look at modern federal criminal defense, it truly is an intersection between various cultures. You've got the prosecutor's culture, of which I was involved in, embraced, and still heavily respect. The defense attorney's culture, different roles, different responsibilities, but equally laudable. Then you've got the cultures in every enforcement investigation of the very entities or areas being investigated. They have their own culture. Bankers, accountants, doctors, the clients that we represent and that get investigated. The only way you can truly appreciate this intersection is by understanding it and looking at this system from all perspectives. So again, this white-collar criminal arena involves the collision of these cultures. It's a unique and foreign language, a strange process to many business people and doctors that we counsel. There are evolving standards, strange rituals and customs. We talk as if everyone understands our language, but they really don't. And again, the effective white-collar defense requires, in my opinion, a thorough understanding and deep appreciation of these cultures and not a resistance to make them all the same. There's a lot of friction in changing a defense attorney to become a prosecutor and vice versa. And in my opinion, the more each of the players in the arena can see it from different perspectives, it makes the system flow. My main goal of the presentation is to present one former prosecutor's perspective of the nutshell summary of the evolution and trends that Judge Horn highlighted. Due to the time constraints, obviously we're speaking at a high level of generality, and you'll probably be relieved that there's very few case citations. And I am putting this into a law review article, so any feedback or comments, feel free to let me know. The genesis of today's presentation was really to try to bridge the gaps between these cultures. And I got tired, or I got very good at, repeatedly explaining to clients why it was that they were facing certain serious challenges and how federal criminal justice got from there to here. The typical first reactions that at least I face, and those of you who practice federal criminal defense law will see when their client comes in, you need to end up going through the pleasantries of the introduction and the kind of spade work. But then when you get down to the rub and say, here's what we're looking at, the first reaction is, look, just make this go away. Or, there must be some kind of mistake. But I'm not a bad person. Why am I being investigated criminally? You mean that I can actually go to jail? I never meant to break the law. What's the big deal? I didn't even make any money from this. Why is this being prosecuted, let alone federally? And again, why is this criminal? Nobody got hurt. Those reactions are very significant when you look at the traditional evolution of where we've come from. The topics, obviously, that I want to focus on in this prosecutorial storm is, first we had calm seas. I keep using these song titles, The Way We Were. But the bottom line is, here's the traditional notion of crime and criminal prosecution. That was the old days, malum per se. Then one force that Judge Horn alluded to was the reduced intent. We'll get into some of the reasons for that. The second evolving force is this over-criminalization, increase in the number, the complexity, and more importantly, the seriousness of the crimes, from misdemeanor to felony. And again, the third force that makes the prosecutorial storm extremely high stakes is the reduced judicial discretion. And I want to close on evaluating these current realities with some recommended responses. Again, back to the calm seas, 40s, let's take us back to 1940s, malum per se. Everyone knew in their gut what a crime was. Rape, robbery, evil-heartedness, bad person. And it goes back to those impacts or perceptions that the clients come to us with, saying, I don't understand this. I'm not a bad person. They're bringing back those old notions of what a crime is. The bedrock principle of criminal jurisprudence is also intentional conduct. You meant to do something, and that something was obviously a crime. All of those have gone out the window. So first, the winds pick up. That's the first sign of the storm. Recognize that the key distinction in regulatory crime, the only thing that really separates a crime from a civil violation is what's the level of intent. So don't underestimate, there is an act in both of those, the actus reus. The only difference whether it gets charged or not is the mens reus. And so the notion of intent as the barrier to a prosecution, if it gets reduced, that is a significant first development. Obviously, I don't want to go into the common law, specific and general intent, and again, the various categories in the model penal code. However, there is this trend of reducing the requirements. Now, why? Again, Morissette quoted the notion, which I love from Justice Jackson, which is the contention that an injury can amount to a crime only when inflicted by intention is no provincial or transient notion. It's a universal and persistent in mature systems of law is belief in freedom of the human will and a consequent ability and duty of the normal individual to choose between good and evil. Well, in making that choice, first you have to understand what's criminal, and that's very significant later on. So first the winds pick up with the lower proof required for the mental element. And there are two what I call windy cases that are out there, one from the 40s, one from the 70s. So it's a slow-moving storm. Dodderwyk and Park, those of you who may be familiar, they're both FDA cases. Again, the president of the company was convicted for violations of the Federal Drug and Cosmetic Act that involved shipping of misbranded products. The crime was a misdemeanor. No big deal, maybe? I mean, no jail time, certainly not by today's standards. Fine and probation. The evidence of knowledge in this setting was the position, the defendant's position, the title that he had was somewhat circumstantial evidence or a surrogate of his intent. He knew or should have known. So again, we're beginning to see this reduction in intent in the level of intent. The justification, this case was really the birth of the responsible corporate officer doctrine, which again is a surrogate that gets the prosecutor on their way in the ability to exercise their discretion. The justification was public welfare. Along came U.S. Park. So the storm brews for 20, 30 years, post-World War II, into the 70s, and we start seeing additional reinforcements of this. Another FDA case, 874 stores, 12 warehouses, 36,000 employees, convicted again of food and drug law, allowing food to be shipped that was exposed to contamination by rodents. Once again, misdemeanor, fine and probation, position, circumstantial proof of knowledge. The responsible corporate officer doctrine is a recognition that certain public welfare offenses are so serious that it's necessary to impose an affirmative duty on corporate officers to prevent or remedy violations. So then you start seeing the distinction between malum per se, which we all get, and malum prohibitum. There's a common misconception that the responsible corporate officer doctrine is strict liability. People have said that. It's really not. There is some level of personal knowledge required for conviction. And this is a diagram that I often use in trying to counsel clients to appreciate, well, I'm not stepping into that position as Senior Vice President of Environmental Compliance. That's the designated felon. Well, it may be, but the bottom line is the intersection, whenever there's information via conversations at the water cooler, emails, voicemails, whatever, knowledge from the plant or out in the field trickling up, and whenever that intersects with the ability to do something about it. If you have an hourly worker who knows that there's a huge problem but can't really correct it, that's not going to be the zone of trouble. That'll be the person first approached as a witness to flip. But the bottom line is, the real intersection is when the knowledge trickles up and the authority to do something about it intersects. And that could be 3 layers in the company. But whoever receives nowadays the BCC and the Palm Pilot and all the Crackberry references, the bottom line is that's where you're going to have the knowledge if you have the authority to do something about it. And that's that zone of again, responsible corporate officer. Also another surrogate for actual knowledge is the willful blindness evidence, which we touched upon. So there's a clash of competing policies that you see in the 70s and into the 80s, which is we need enforcement where the public needs protection. Therefore, let's abandon the historical notion which separates civil from criminal by reducing the proof required for general intent. That's essentially the first force in the storm. Now, high winds are okay as long as that's all you got. See, there's a sailboat and they seem to be enjoying themselves. But because at the time, it was only misdemeanors, infrequent prosecutions, last resort. You don't prosecute, you go after them civilly or administratively or debarment or licensing. Again, regulatory phenomenon, lower priorities nationally. So with the winds came the rain. So the second force in this storm was this expansion of federal criminal law, and we could spend a whole hour on the cycles of crisis. Congress perceives something, the S&L crisis, what happens? Criminalize it. Environmental, oh my God, Love Canal, what do? You criminalize it. Healthcare fraud, doctors are triple billing, what do? You criminalize it. So again, we've become addicted to that being the solution. Throw them in jail, let's have 1 or a dozen or 100 caught, and make the penalties by design draconian so others in the industry wake up. What used to take 1,000 civil lawsuits can be corrected in 1 or 2 significant federal prosecutions. People say, this is unfair. Well, the bottom line is it's unfair when I get caught on 85 going to Gastonia with 9 other people going faster than me. I'm the only one that got caught. The mom, everyone else is doing it, doesn't cut it in the federal arena. So again, accounting reforms recently and the Enron, Tyco, and again, this is not something that's ever going to change. But interestingly, they never go away, these crimes. Now, that's not to say that in the criminalization of regulations, there aren't bad actors in each of these areas. And what I've tried to show here is kind of the bullseye target is kind of the rings of what people perceive as criminal culpability. Obviously, the prosecutor sees this huge segment of the industry as crooks, criminals. Just prosecute them. If you can prosecute them, prosecute them. Again, we'll see that impact on the discretion. The blue and the red we'll call it the jury zone. What is the jury likely to do? Will they always find everything the prosecutor does? Probably not. If you're prepared and good lawyering, you'll end up having some in this zone. And of course, the heroes in the system, which I've now adopted, is the golden ring, the inner sanctum, the defense attorney, and his view or her view is that, sure, there are a select few that are truly bad actors. And those are the ones that when you get them as clients, you just make sure you get a huge retainer, because there's not much you can really do for these. But the bottom line is, very rarely do you find criminal defense practitioners worth their salt saying, no one's ever guilty. It's just a question of which zone does it fall in. So again, and that's where that perception of how you define criminal liability and the appropriateness of turning on the federal machine is always going to differ. The prosecutors and the defense attorney will never agree on the exact every time, and that's the process of obviously the plea negotiations. So with the winds came the rain. There's this creation and maintaining of criminal enforcement machines. And with that, this is an FBI story with James Stewart, with that is inertia. You got investigators, you're hiring them, you're training them, you get a network. Well, what happens? This is another interplay with my science background. Newton's first law of motion, an object at rest tends to stay at rest, and more importantly, an object in motion, i.e. a bureaucracy created, tends to stay in motion, stay created, with the same speed in the same direction, unless acted upon by an unbalanced force. Nothing has acted in unbalanced force in the criminal arena to bring it back where it used to be. It's ever expanding. Objects tend to keep on doing what they're doing. A body in motion remains in motion. Federal criminal agencies tend to remain and even grow once created. Now, the initial focus is fine, because once Congress says, oh my God, there's, the sky is falling, there's all these criminals in every, corner, the laws are passed, the prosecutors are just, it's a target-rich environment. They go out for the low-hanging fruit and knock them off, easy pickings. But what happens after 3 or 4 years when the rational business people adjust their behavior and start not engaging it, setting up certain compliance efforts, and then suddenly it becomes a little harder to get, a little less obvious in, did they really engage in it? The problem is they've got that enforcement network created. What are they going to do? You know what? Let me shift from this area and let me change into a completely new agency. That doesn't really happen. So the bottom line is, over time, they start climbing up the tree and start making closer calls, less black and white, obviously criminal, into some troubling areas where maybe it's appropriate for civil. Massive increase in the number of federal felony crimes. Over 4,000 offenses currently carry criminal penalties in the U.S. Vast majority of those are felonies. 33% increase since 1980. I found this interesting, more than 40% of the federal crimes enacted since the Civil War have been enacted since 1970. Again, right around that trend that you saw in the reduction of general intent. And you've got massive and broad prosecutorial discretion. And that's great as long as the people at the helm are trustworthy and frankly experienced in the business arena to be able to parse through and identify who are the bad actors in the hospital context, who are the bad actors in the environmental context, what's the benchmark to see whether they're worthy of a passover or a judgment call. That's where the rubber's going to hit the road now and in the future. New and expanding enforcement priorities. We heard about President Bush's corporate fraud task force. 250 convictions within a year or two of the creation of the task force. It's remarkable. 70% of these led to prison sentences, and FBI investigations into corporate fraud alone have increased by 80% over the past year. Again, look at the size and number of federal prosecutors, FBI resources, and budget. I think when Judge Horn was at the U.S. Attorney's Office, how many were there?
7.
7. Josh, how many are there?
30 plus.
So there you go in the course of a decade, not even, or a little over a decade to go from 7 to mid-30s. Again, you've got what used to be a broad discretion, what conduct should be prosecuted, and again, that's a higher standard, versus what can be prosecuted. Congress, by design, wanted to keep this low. They're criminals, right? The malum per se stuff, the bad actors. Why would you want to set it high? Set it low, and the prosecutors will sort them out. The problem is there's now a narrowing. So if you can, the low-hanging fruit tend to be gone after a couple of years with rational business adjustments. If you can, you should. If you can, do it. Otherwise, statistically, we might be soft on crime. That's not good. That's not a good thing for budget. It's not a good thing politically. You either use your money or you lose it. So again, the dangers are increasing for the regulated community, and this is ultimately going to lead to the concluding remarks. The discretion of the prosecutor deals with the targets as well as the charges, kind of who to charge, both the company and the individual, and what crime. Third, you've got the high winds we talked about, then the rain, and then lastly comes the lightning, which is the third aspect of the prosecutorial storm, which is the sentencing guidelines. That severely limits judicial discretion and gives the mandatory jail time even for the first-time offenders. In short, the federal crimes, vast majority of them carry mandatory jail time. I don't think that's a surprise to anybody now. It often is a surprise to many of my clients, unfortunately. And then when they don't like what I hear, they may go to Ed Hinson to see whether Ed can come up with a different answer. And when they don't, it becomes very frustrating because, unfortunately, it's the reality across the board. So we got reduced mental element, general intent, interpretations, increased number of wide variety of vague and complex felony crimes, abundant investigative and prosecutorial resources, broad discretion, mandatory jail time. That makes people very nervous. The underlying rationale for the changes, think about this. Why did they lower the mens rea? Public protection. Same thing with why more business crimes? Public protection. And again, restricting judicial discretion was more of consistent punishment. But again, the theoretical goals, and the goals and underlying motivation was well-intentioned. Prevent, deter, and punish bad corporate behavior. In the parlance, jail time is the stick versus the carrot, so use it. I did a search with all the U.S. attorneys' offices across the country, and within literally 30 seconds on each of their websites, whenever an indictment goes out, the most common phrase in the U.S. attorney's indictment press release is, send a message. Let this prosecution, let this indictment, let this conviction, we hope it sends a message. Because again, they want to end up deterring, even if it's draconian, even if it's overkill. So again, the notion was, with the guidelines, give defendants similar punishment for similar crimes. Well, as my mentor, Judge Mullins, who's an alumni of Duke, used to say, consistency is the hobgoblin of small minds. Now, Judge Mullins has a tendency to kind of just wax poetic, but there's something to be said for that, because there are other sides of the coins that we just assessed. The proof of intent is circumstantial. So the practical definition becomes, do we have enough for intent? Well, what do you think? Will the jury convict or not based on this? It's not kind of a objective assessment. Will they convict or not? That becomes the test. In my opinion, I venture to say that's dangerous. To change bad behavior, the target defendants have to know what is bad. Otherwise, you result in, with overly complex crimes, resulting in the risk of prosecuting accidents or mistakes or simple negligence. Again, is punishment now any more consistent? Usually, in the old days, the investigation, charge, trial or plea, and sentencing, it ultimately boiled down, the focus was at the end. Let's see what happens at the end in terms of deterrence and punishment, and who makes that? The one who listens to both sides, the judge. You hear from the prosecutor, you hear from the defense, and you make a call and you give the punishment based on that person's background and the facts of the case. Now, the focus is at the beginning, at the charging decision. Now, this is where you get into some controversial discussions about where is it preferable. Do you want judicial discretion in imposing the sentence, or do you want prosecutorial discretion in charging? I venture to say that two individuals at different parts of the country 30 years ago may have gotten different sentences because of the judges. Now, they're getting different sentences because of the prosecutor's charging decision. And the improvement is kind of Pyrrhic. It's a Pyrrhic victory. So, as between the judge, the prosecutor, and the defense attorney, if you look at that triangle, the two parties advocating to a central objective third party, what would the reaction be if anyone said, well, you know what, the prosecutors have had their turn, let's go ahead and allow the defense attorney to have its couple decades in deciding punishment? It would be ludicrous. They're an advocate. But that's exactly what happens in the prosecutorial arena, because the charging decision dictates, if anyone's familiar with the guidelines, dictates the outcome at the end. Okay, are we facing the boiling frog syndrome? How many people know what the boiling frog syndrome is? For those of you who don't, I've been understanding, and it's kind of cruel. I don't know whether anyone's ever tested this or not, but if you throw a frog into a pot of boiling water, he'll jump out. But if you place a frog in a pot of lukewarm water, see, I'm afraid, I've got a 7-year-old. If I told her this, she'd probably do the experiment, which is kind of creepy. But if you place a frog in a pot of lukewarm water and slowly turn up the heat, it'll boil to death because it never really feels the changes significantly enough to do anything about it. So I raised the question at the end of this section, are we facing the boiling frog syndrome? That may be the case with, again, there's a lot of articles that compare it with companies, with inflation, but the notion of federal criminal law, have we grown accustomed to over-criminalizing over the past 30 years? Just because we've grown accustomed to it doesn't mean that we don't continue to be hurt by its effects. So I toss that out just for consideration. Would the changes that I've gone over have been acceptable if they were proposed simultaneously, like dropping the frog in the hot water? Will the current arrangement remain in place? I doubt it. We're seeing in Blakely and other challenges before the Supreme Court a troubling disturbances about the balance of power and the checks and balances. I think that's healthy. It's confusing as hell, and it's hard to kind of keep adjusting as a practitioner, but it's a fascinating area. Who knows what the future holds other than change? Will the frog jump out, or will it just get boiled? It remains to be seen. Part 2 of the presentation, really for the next 15 minutes, is now that we've talked about the realities and shown the evolution, the issue is how do you survive at sea in this prosecutorial storm? The first is trying to convince this man and all of his colleagues, which again, he is a laudable guy. I've had great respect and great dealings with Josh and most of the people in that U.S. Attorney's office. But again, they've got the leverage by design. So how do you counsel clients on the front end of avoiding getting charged? And then secondly, if they don't listen to reason and they do feel overzealous, how do you win at trial? How do you go and get an acquittal and put it together? Recognizing that if you exercise your right to trial, the sea is deep, my friend, and the defendants sink far, if they lose at trial, far deeper than they used to. The goal is to understand and influence. The second part of that is more important than just the understanding. Understanding and influencing the prosecutorial discretion. Demonstrate good corporate citizenship. Don't just claim it. Everybody being investigated says, hey, we're a good corporate actor. It's kind of like their, well, I don't want to say it's kind of like their 10 Qs, but bottom line is they all claim it. You have to demonstrate it. You have to show resources, show funds, positions, to show that you're taking self-policing seriously. And avoid being perceived by the government as a bad actor, because the government's perception is reality. Once the whistle's blown and everyone kind of realizes there's an investigation, you can't claim at that point, oh, you know what, now we get it, we'll go ahead and implement these changes. That's viewed as a bribe, informally. It's viewed as buying your way out. That's not acceptable. You had the opportunity beforehand. Query whether they did, because of this misunderstanding and different cultures. But again, that's the most important thing, and it changes the notion of the role of the modern federal criminal defense counselor. In my opinion, and the way I structure my practice, I am no longer only the reactive force that comes in during a search warrant, subpoena, or indictment. You have an obligation with clients that you bump into who are the first responders, corporate counsel, lawyers at firms that do civil work and no criminal, to alert them to these kind of fire drills. Because the government counts on them not being aware or expects them to be aware, and they assume that the cultures is fully exchanged, and it's not, as we all know. One of the things you look to since 2003 in looking at what is the prosecutor's primary guidance on charging discretion and how do you influence it is the Thompson memo that Judge Horn referenced. And the two basic questions in the memo is when should corporations be charged and what factors should be considered. Here's a litany. You can get it on the website. The memo is very interesting. It's a little long, but the bottom line is, not surprisingly, similar to the criteria in whether to charge an individual, you look at the nature and seriousness of the offense, how pervasive of wrongdoing within the corporation, i.e. where in the chain was the wrongdoing, the history of wrongdoing. Again, have they gotten past warnings, past knocks on the door that they just ignore? It's not a big deal. Again, those things are cumulative and add up. the timely and voluntary disclosure of certain problems, the responsiveness to it, the existence and adequacy of the compliance program, their remedial actions in correcting the harm that they caused, collateral consequences, and adequacy of prosecution of the individuals. Do we really need to go after the company, or is it really one bad apple? Or is it the culture in the company? Now, how do you define what a culture in the company is? That's, again, the next 10 years we'll have some definitions over that. Because, again, they're going to disagree. We got a great culture. No, you don't. You have a terrible culture. Well, ultimately, it's up to the jury. That's not going to be the basis of Rule 29 to make the case go away, mid-trial. So ultimately, none of these are enforceable. It's just things to understand the way the prosecutor approaches these things. More importantly, the poster child of preventive law is the compliance program. What is it? The government's going to look to see whether there are corporate governance mechanisms to detect and prevent misconduct, directors' oversight of compliance. It can't get the second shrift anymore. If it does, again, it is a huge risk. You need to have resources and staff sufficient to audit, document, analyze, and use the corporation's compliance efforts. Paper tigers, frankly, are worse than nothing. It's far worse to have something in place that's insulting, that is not real, because it's cheap. And that's worse than not having any compliance, because at least then you're being upfront and not trying to mislead anybody, saying, oh, our compliance program is great. Again, do the employees know and buy into the compliance program, which gets largely into culture? Obviously, we've talked about some of the range of legal services for today's federal criminal defense lawyer, both proactive and reactive. Frankly and unfortunately, you make more money off the reactive. So the old slogan, pay me now or pay me later, it's unfortunate. But again, a lot of us are going out into companies trying to end up getting them to be more proactive, so we don't have the perception of being vultures picking on the bones when the feds come in. But they'll pay you much more readily after the vultures are there, trust me. But it's your ability and range of options at that point have been severely restricted, plus your business transcript essentially has been fixed. Your compliance record, to use an appeal analogy, has been set by the time that whistle's been blown. Obviously, the proactive counseling is this preventive notion, corporate compliance. This used to be just the subject of corporate guys. Now it's corporate guys and criminal guys, because they want to know, how's this going to play out? Search warrant response planning. People say, well, how can you plan for a search warrant when you don't know what's going to happen? You look at the Fortune 500 and really pay attention to how many of them have been searched, one of their facilities in the last 3 or 4 years, you'd be amazed. Hundreds, if not thousands. So having a corporate response plan in the event that any facility gets searched, this is what you do. This is how you inform people of what their rights are. This is how you protect the company. That's all proactive stuff. The reactive stuff, obviously, is the grand jury, the search warrant, the internal investigation, the interviews, the documents, negotiations, litigation, defense. That's the classic old school criminal defense, which again is still the most lucrative. In this climate, the recommended prescription is you try to prevent, detect, and correct problems and develop and implement these compliance plans. Most significantly, the prior standard was if you had a corporate compliance plan, that was evidence of good faith. That's kind of like a merit badge. You did your good deed. Only 10, 20, 30% of the industry set one up. Now, in this prosecutorial storm climate, the absence of a corporate compliance plan is evidence of bad faith in many prosecutors' mind. How could you not, after 15 or 20 years in this climate, how could you not have set up a system? You are not taking this seriously. You operate at your peril. In tandem with the lower intent, the higher resources, the broad discretion, you got a battle on your hands, and the costs and consequences, if you guess wrong, are unbelievably draconian. So the notion of front-loading that preventive aspect and prioritizing it cannot be emphasized enough. We're in an era, obviously, of high stakes, aggressive prosecutions, high priority, high resources, high profile in media, and the deck can be stacked. It's not always, but it can. I venture to say even Microsoft was well matched with DOJ. And I mean, there's not many companies bigger than Microsoft in terms of the ability to fight it, and they didn't really fare too well in terms of the notion of, are they on a level playing field? So those majority of companies that don't have a Microsoft or a GE or an AT&T. I mean, it's frightening. The antidote to that broad discretion of the prosecutor is, again, these objective compliance efforts that, again, you've got to go beyond good intentions or hollow corporate policies. Compliance is the equivalent of the most effective form of insurance that any company and executive can have. First, it is your ability to influence the prosecutor to avoid the charge. Who would go after a company in the top quarter of their industry sector? Something's going on. No matter how good the compliance plan is, there's always going to be mistakes. There's always going to be rogue employees. But the ability of a prosecutor saying, a jury's going to know all of this objective proof with expert testimony about what others in the industry are doing compared to the client, if they're truly at the upper quartile, that may be worth a $10 million discretionary call not to charge. So the notion of not just passing over that as, you know what, we'll deal with the compliance garbage once we get charged. No, that's called a probation term for 5 years. And if you've ever tried to counsel a client who has a representative attend board meetings, an outsider attending board meetings, it's not pretty in terms of corporate dysfunctionality for 5 years. You want to talk about an interloper and the inability of people wanting to serve on the board anymore, it's a wake-up call. So the notion of front-loading it cannot be overemphasized. Again, if the prosecutor, and this is perhaps the most significant point in this whole presentation, if the prosecutor, being used to this leverage and increased resources, is overzealous and unreasonable, you've got the ammunition with this good corporate efforts documented, demonstrated, to convince a jury. If the prosecutor's not going to be reasonable, you're going to take it to the jury, and at least you've got something, even in this climate, to say, this is our ammunition for defense. Again, that will be probably one of the few things that will justify the chance for an acquittal in this climate, because the juries are going to hesitate to convict a company or an executive who was committed and can point to it to demonstrating compliance. Why waste time indicting or convicting a company at the top 25%? Obviously, the ammunition that I love having when companies have it, I wish to say that they had it more frequently, is this compliance plan, corporate mission statements, code of ethics. We've all heard about it. Assembling past awards, industry and governmental, documented investments, positive press release, all of that corporate priorities, but going beyond just announcements into real dollars. I heard an estimate once that for every 100, it should be 1% of every gross revenue should be compliance oriented. So that tends to be what I've heard is as far as the standard of what you may or may not be judged by. Obviously, we're all familiar with the near irreparable harms from criminal convictions, mandatory jail time, massive fines, corporate probation, and money. You'll be scrutinized beyond belief in future dealings. So the lessons learned from those companies, you look at the most significant voluntary efforts by companies, 90% of them come from people who have been convicted, that have gotten religion, and they've gone ahead and implemented things that are meaningful. Allied Chemical in the 70s has a phenomenal compliance program. Why? Because they were prosecuted. And then they finally woke up and said, we can't really resist this anymore. Let's get better than what the government requires. And that mindset and that shift by saying, okay, here are the regulations, we're going to exceed it, and that gets us prosecution insurance. Or executives who've been with companies that got indicted, they left and want to make sure that their new company isn't going to suffer the same parade of horribles. That never again mentality cannot be underestimated. The economic costs, again, the notion of what you have to invest to regain your reputation, it's far more cost effective not to lose it in the first place. And again, a compliant company is a more valuable company for merger partners. If you don't have any ghosts in the closet, people will pay more for the company. It takes 1 to 5 years to get in real trouble with regulators. That's civil. It can take 25 to 50 to get out of trouble. So obviously, the cost effectiveness pointer is maintain the effective compliance program. It's a fraction of the costs arising from the criminal investigation and prosecution. And again, thank you very much for your attention, and we'll be happy to take any questions you guys have. Otherwise, I think we're right on schedule. So.
Any questions?
Go for it.
Any tips on marketing yourself to the business community for proactive
Intervention. Everyone heard the question in terms of marketing for the proactive, preventive stuff. What I've been doing is really just to try to get inroads to companies, to give similar presentations to this, to kind of focus on case studies. I'm also working with some of the larger insurance companies. The problem is now they've got their own set of issues. We were very close actually to creating a new product for white-collar defense insurance costs that was tied to preventive work on the front end as the way to get into the pool, because essentially you're insuring against nothing that would have a certain level of premium, certain level of deductible, and then a cap. And we were very close, kind of business-wise, of saying, look, nationally we can do this. Let people separate themselves, the wheat from the chaff, but give them some monies and incentive to do it. And now with the ongoing investigations, that's probably off for a couple of years. But I just think it's just pounding generalists, and certainly the prosecutions that the U.S. Attorney's offices across the country. I mean, it's sad to say, but you know, sometimes their theory works, and that an aggressive prosecution will make people say, you know what, maybe we need to prioritize that and spend some money on it. But it shouldn't be that way. The more aggressive people are in the local area in prosecutions, the more compliant I think the defense bar, more compliance-focused the defense bar is. So, but sometimes you get visionary managers. So, yeah.
Newspaper reader, the practice of earnings manipulation seems to have increased over recent years. From your perspective, is this a valid observation, or is it just being publicized more?
In terms of the number of investigations?
No, in terms of the actual manipulation in annual reports. Quarterly reports, the report of the profits seems to be, every time I pick up a business section of
Right.
a newspaper, there's another company in there who's being called to task because they manipulated earnings in a way that misrepresented their actual profits.
And that's the $64,000 question. I think no one knows the answer to that. I think what happens is in flush times during the 90s, people are less concerned. It's kind of like it's high tide. So all the nasty stuff that's going on down in the bottom isn't really present. People don't care if they got defrauded on one deal, they'll make it up on the other. Everyone's flush with money. But as the tide goes out and the economy starts to get a little bit leaner, a lot of stuff, you know, comes to the surface, and it becomes kind of easy pickings. But you know, look at how fast the S&L in the 80s. It wasn't like it was 100 years. I mean, the 80s, and then it seemed to kind of compliance plans in the healthcare and environmental started, and then boom, it's back up again in the late 90s, early 2000s. I mean, maybe people do push the envelope when they're not being watched, as opposed to doing the right thing for its own sake. Because again, it costs money. So, and maybe it's the shareholders' expectations. I mean, that's my frustration. Shareholders, if given the choice between investing in compliance versus kind of increasing their shares each quarter, maybe you get what you prioritize. So I don't think there's a clear answer, but if anyone else has any other insights, I mean, it's a great question, and I don't know if anyone knows the answer. But okay, one more question.
Do the federal and state investigators have some impact as to who to charge and how much? And if so, have you had any ability to work with the investigators and your client to help prevent the problem?
Depending upon the timing issue, if I hear, first of all, the model, the question is there a lot of interplay between state, local, and federal, and you know, can you get involved and influence their decision making? The answer really is how early you get on. The model that worked in the drug scenario, where you've got local, county, state, and federal working on a task force, is really being modeled in the environmental arena, the healthcare arena. They all get together. If you are perceived as a bad actor by a civil regulator, that is not a good start, because they do have the ability to meet monthly or quarterly and say, you know what, I don't really think that these guys are giving me respect, therefore I'm going to end up turning up the scrutiny. So that's one observation, and I give a whole different presentation on how to maintain regulatory relationships to prevent a prosecution over a year and a half, and there's some concrete steps that people need to do, because, and briefly, what I often focus on is treat your regulatory relationships like a real pain-in-the-butt customer. Just like the customer you got to tolerate because they bring in lots of money, that guy's difficult, but he has the potential, or she has the potential, to take out a lot of money. So have one person designated to deal with the regulator, so that if for some reason in January they say, we'd like this area cleaned up if it's an environmental case, or we'd like this report coming in, and you blow it off, they come back 3 months later, they deal with a different person. That regulator thinks you're disrespecting him or her, and they're going to take it to the next level. You can influence their discretion if you get in early. Unfortunately, if it's too late, their mind may be already made up. They may say, okay, we're not going to go after these charges that carry 7 or 8 years, but you're not getting away with anything that's non-criminal. Oftentimes, the minute a client comes to me and says, we've heard these rumors, you immediately initiate a dialogue with the source, try to take the temperature of how bad it is, and then if it's really bad, you want to focus on not talking with the regulator right away. You want to get it and correct the problem, because once you contact them, the bell gets rung and kind of your record is created. So I often get to the bottom of it, terminate the people that you know are bad actors, not haphazardly, but just after a thorough investigation. Then you go and say, look what we did. We took care of the problem ourselves. And then you get on your knees and you say, please, Josh, please don't charge us. So I've charged these guys a lot of money, please. So anyway, thank you very much for your time. Thank you. Appreciate it.
Thank you. You need to do everything's fine. Our next speakers, they're standing out there. I thought thought they didn't see me, I guess. Yeah, no, here they come. Here they come. When I put this seminar together, I've had the pleasure of teaching ethics here at Duke University, and I've also had the pleasure of working with Bryan, who is one of our next speakers, on putting on seminars to in-house counsel and to others, talking about the ethical considerations and dealing with the issues that Pete has just been talking about. And I was able to convince the CLE people that we would put an ethics spin on the way we present this white-collar crime, because it is a huge piece of the action. How y'all gonna divide the program up, Mike? Is Barry going?
Just come up there and
okay.
have some panel and
Yeah, come on.
get some conversation going.
Very good. Come on up. I want to thank both of these fellows. They were in Atlanta last night, and I got an email this morning saying that Barry wasn't going to make it. His flight from Atlanta to Raleigh, Durham had been canceled. I sent an email back and said, well, get me his material and I'll fake it. But I'm delighted that Barry made it. To my immediate right is Michael Bryan. Mike is a partner of mine in our Charleston, South Carolina office, and he came to Nelson Mullins from a stint in the Office of General Counsel of the Monsanto Corporation. And he's going to focus his comments on the client, the corporate client. Barry Alexander joined our law firm, and he's in the Raleigh office. Barry is a graduate of George Mason School of Law and practiced in the Washington, D.C. area for 6 or 7 years, and focused primarily in defending people in false claims in Medicare. And he's going to look at the individual client and talking about how to deal with the individual client and the issues you face dealing with the individual client. And Mike's going to focus on the features with the corporate client. And if you look at our program, the next step in this presentation, it's an orderly presentation, is that Judge Mac Howard and Josh Howard are going to talk about how to deal with the prosecutor in the court. And we're going to end this presentation by two individuals who actually went through the process and actually served some time for being convicted of white-collar crimes, and they're their reaction, what they view the lawyers can do for them, and the mistakes that lawyers make inadvertently and so forth. So I think it's going to be a fascinating program. Following Mike and Barry's presentation, we're going to take a recess, and out in the hall I've got some soft drinks and some candy to perk you up a little bit. And again, thank you so much. And I'll turn it over now, Mike or Barry, however y'all want to have it. Thank you.
Thank you, Judge Cox. As Judge Cox said, we are going to talk a little about dealing with the corporate client, and I know that you've spent some time on that. We caught just a little bit of the last speaker from outside there, but we'd like to spend a little time on that and focus maybe some of it on the distinction between the corporation and the individuals within the corporation, the constituents of the corporation, and the representation of the corporation and how you can get yourself in trouble and how to hopefully stay out of trouble in dealing with those individuals, because, of course, that's all you can deal with when you're dealing with a corporation. I was coming in from Atlanta this morning. Actually, I had an earlier flight than Barry did, and I was sitting next to a very talkative gentleman who proceeded to tell me, well, most of his life story, but also told me that he was a speaker. He was a trainer of speakers, of public speakers. And he said, "What are you going to Raleigh for?" And I said, "I'm speaking this afternoon." He said, "Well, do you have something? Do you have a good opener?" And I said, I don't think so. I guess I do." And he said, "Well, hang on a second." And he pulls out a handheld computer, and he said, "I've been doing this for, 12 years, and I've got thousands of jokes on here." He said, "What's the topic?" And I said, "It's white-collar crime." And he said, "All right, hang on." And he punches it, and he punches, and he goes for a long time, and he finally says, "I don't have one for that." So I don't have one for that either. But anyway, I thought I would. I'm the non-criminal type here, hopefully in both ways. But I'm non-criminal lawyer. I've done securities work and do a lot of corporate and M&A work, and so I'm going to talk from the viewpoint of the securities lawyer, the corporate lawyer, the commercial lawyer who's representing a company and comes across something that could be a problem, either civil or criminal or a little of both. We've got a hypothetical. I don't know if all the books have been handed out. I hope there were enough to go around. Does anybody not have a book, and are there any extras anywhere? We've got here and here. If there are any extras, hopefully we can get them to those folks. But we've got a hypothetical we'd like to set up, and we'd like to get everybody involved and like to get everybody's thoughts as we go and get some discussion going and hopefully some good debate about the way to approach some of these issues. So if we can, I think we can go through the hypothetical fairly quickly here.
And before we jump into it, maybe you could help us just get a little sense about your practice areas. How many people here work with public companies? Okay. Represent them or work in-house? How about nonprofit organizations? Nonprofit organizations? And how many people work with small startup companies here, for example, in the park? How many people have lived through a civil or criminal investigation by our good friends at the Justice Department? You're on the good side now, Pete, right? A few. Okay, well, we're going to jump into a hypothetical. Mike's going to take us through it, and then we're going to kind of split how we're going to discuss some of the various aspects, corporate, individuals, challenges, things to do.
And we'd like to get you all thinking about how you'd approach these things. And we'll go through this very quickly. I'll try not to read it to you, but I want to kind of take everyone through it. Our company is Chemco. It's a Delaware corporation based in Raleigh. It's in the business of, it's in the chemical business, making and selling chemicals around the world, about a $2 billion company. It's public, listed on the New York Stock Exchange. We have an employee named Jones, who's a mid-level employee working in the accounting department. He has become concerned about accounting irregularities. Particularly, he's concerned about booking some sales as revenues in the company's books that relate to a contract with a major distributor of this company, and we're calling that Distribco. Under this contract, I promise this is as detailed as we're going to get, but we need to focus on it just a little. Under the contract, Chemco ships or keeps product at its warehouse, puts some in rail cars out behind the warehouse, and has a contract to deliver that upon Distribco's order to the retailer. And until it's shipped, until they get the order, they keep it there. They also don't get payment for 30 days after they ship it to the retailer. And there's a side agreement that Jones finds out about from one of the other employees that says that at the end of it's a 9-month contract. At the end of the contract, anything that Distribco hasn't sold to a retailer can be returned or basically left at Chemco's facilities, and they don't have to pay for it. If you're familiar with the Gateway enforcement action, Gateway Computers, it's somewhat similar to what happened or what was involved in that enforcement. So Jones has become concerned about this. All the revenues under the contract are booked in December of 2003. The contract is signed in December of 2003, and wouldn't you know, all the revenues are booked that month. A little bit later, he tells his supervisor, Smith, he's concerned about this. He's not feeling too good about it. He expresses his concerns, and Smith says, I'm sure it's fine. Comes back a few days later, says, I've checked with the CFO, and the CFO says, it's all fine, don't worry about it, keep booking sales this way under these contracts, and don't be talking about this with anyone else either, and just, keep your head down and do your job. And Jones is not eager to get himself in the spotlight in that sort of way anyway, and so that's what he does. In March of 2004, the company releases its earnings for the year 2003, typical earnings release and so forth. And in this earnings release, they highlight the fact that U.S. sales were up in the last half of 2003, and wouldn't you know, this contract accounts for about 80% of the increase for the entire year. So it's front and center in the earnings release in March. Well, this doesn't make Jones feel all that good. He realizes this may be a bigger problem than he thought. He's never been completely comfortable with it, but now it sounds worse. Chemco has about 10 in-house lawyers in its legal department, headed by the general counsel. They use the firm Dunn & Webb with about 120 lawyers as their primary outside counsel for securities and corporate work and some of their litigation. There's an associate at Dunn & Webb named Rogers. She has worked with Chemco on a number of matters. She's a commercial lawyer, has done a lot of distribution contracts, but in our base facts, not this one. So Rogers happens to know Jones on a social basis. They belong to the same club. She sees Jones once in a while. She once reviewed a lease for Jones just as a favor, didn't charge him, looked at the lease for his wife's property, and they're friends. Well, he runs into her at a social function, and he's been worried about this problem, for weeks now. He pulls her aside. He considers her a friend, and he tells her about what's been happening. He tells her about the booking the revenues in December and about his concerns and about the fact that he told Smith. Smith came back and said the CFO said, this is fine, keep doing it, and don't talk about it. And he says, he says to Jones, to the associate, he says, don't implicate me if this is a problem. Just, this is just between you and me. Let's not tell anybody. Don't say anything to anyone. Now, Rogers is a fifth-year associate, right out of law school. She went to this firm. She's been there ever since. She does commercial work, works on contracts, and is not necessarily, at least in our base facts, is not a securities lawyer. So the first question is, what are her duties? What does she do? She goes home, she thinks about this for a minute, she says, wait a minute, what did he just tell me? So what does Rogers do? What are her ethical duties? What's the first thing she should do the next morning when she gets to the office? Any suggestions? Should she report this? Should she think about it? Should she follow up with Jones, with the person at the company? Should she follow up with someone she knows at the company? Should she talk to her boss? She reports to her team leader, who reports to the group leader, who's the senior partner in the firm. Any thoughts as to what she ought to do? How about, it's a public, go ahead.
Well, I think she should report it to her partner. and under probably the ABA model rule 1.13 as it's been revised recently, she's probably got to go up and maybe out, or potentially has to.
And that's in your materials, 1.13, the model rule and the North Carolina rule. We can get into, if you want, how those differ. But I think under the rules, she represents the organization. She has to do what's best for the organization, which might include doing something about this, not just waiting for the organization to call her and ask her to do something about it. She may have to take some action on her own. Under the new attorney reporting up rules, under Sarbanes, Rule 205, SEC Rule 205, she also has a duty if she learns of evidence of a material violation, which can be a violation of law or fiduciary duty. And if she is, the term is appearing and practicing before the SEC. And that gets a little complicated as to what's appearing and practicing before the SEC. It's worth discussing, I think, the fact that you don't have to be a securities lawyer to be doing it. You don't have to be doing securities work. You can be representing a public entity, a public company, and doing any work on any contract or matter that will be filed with or furnished to or submitted to the SEC if you know or have reason to know, and it gets a little ambiguous as to what they want right there, what that standard is, that it will be filed or furnished to the SEC. So a litigator, for example, who's handling major litigation for a public company, say it's toxic tort litigation, a major piece of litigation, gets an email from his contact inside the company, says, please take a look at this, at the attached document. This is from the 10Q, our next quarterly report. I revised it from the last one. Could you make sure that there's nothing to update on this case, the cases out west? That attorney is appearing and practicing before the SEC because he or she is looking at a document that's going to be filed with the SEC. And this person is not a securities lawyer, is not doing anything else with respect to securities matters, a toxic tort defense lawyer, for example, in this case. So you have to ask yourself, am I appearing and practicing? You might be, and you don't really think about it. It's not necessarily obvious that you're doing that in all cases. So if she's appearing and practicing before the SEC in the representation of this company, and she sees this evidence of a material violation, she has a duty to report it up. Now, her immediate supervisor is her team leader. Under the rules, generally she needs to report to her supervisory attorney. And that is generally under the rules the person that you're reporting to on the matter that this relates to. It might be her normal reporting person, it might not. So under 205, if this is an evidence of a material violation, she needs to report it to her team leader probably. Now the question is, she's not a securities lawyer. So what does she do? She thinks that she knows Smith and she knows he's an up-and-comer in the company. The CFO, she knows by reputation. She thinks they have sterling reputations. She's never known of any problems like this at the company. Does she see evidence of a material violation or not? Or does she just see one person who's, he's a mid-level person. Maybe he's not familiar with the subtleties of the accounting rules and under which they can book this as revenue. Lots of people spend a lot of time arguing about these rules day in and day out. Dozens and dozens of people in any size company with the auditors and the lawyers and the accountants inside the company argue about these things ad nauseum. So maybe Jones is wrong. Maybe Jones is just a little off base here. So she's going to be judged, in hindsight, she's going to be judged in her determination as to whether she saw an evidence of a material violation. And there's language, I think, in the release that seems to indicate she will probably be judged with respect to her experience level and her expertise. So maybe she really, under the rule, doesn't have any reporting obligation, but under the state rules, she clearly probably does, I think. Let's assume that she's a securities lawyer. There, I think, clearly she's held to know a little more about this and to at least know there's some smoke here. And there's language in the release that seems to indicate that in order to be reasonable, you might need to consult with colleagues. It indicates that one of the factors in determining whether you've been reasonable in ferreting out a problem is whether you've had the opportunity or whether you're in a situation where you have the opportunity to consult with someone who might know more than you do about it. So the rule probably requires her to at least say, there seems to be some smoke here. I better talk to one of our securities people. I better talk to my team leader or someone. So Let's assume she doesn't do anything, though. She decides Jones is off base. Later, she learns, a few weeks later, that Jones has been unexpectedly reassigned to the bookkeeper position in a small sales office in a small town in Kentucky. Clearly a demotion, probably near the small town in Kentucky I grew up in. So it's definitely a demotion. After this, Jones files a lawsuit for retaliation. And in the course of that, he wants to keep Rogers from revealing their conversation. Is he going to be able to do that? And if so, how? Is she his lawyer?
No. She's the corporation's lawyer, although if there was an expectation of confidentiality, she may have a conflict.
And she talked to him at the party. She had looked at a lease for him some months before as a favor, just as a friend. Spent an hour, read the lease, told him what she thought.
She's got to assert the privilege, but and let somebody else make the determination. I think probably she had enough of a contact that she established an attorney-client relationship with him.
And isn't that in his mind? Isn't that what counts? It's whether he thought there was an attorney-client relationship established, and so maybe she should have said something when he started spilling his guts at the party. She should have said, "Well, hold it right there. Let's talk about this at the office tomorrow," and then kind of gotten the situation under control. Said, we represent the company. We're going to need to take this in a more controlled fashion than sort of an off-the-cuff, just remarks at a social event. So I think she needs to be on her toes. She needs to be, because in-house lawyers have it even worse, because an in-house lawyer is walking down the hall, in the cafeteria, and people come up and say, "Hey, did you hear about such and such over here?" And many times you have to stop them and say, "Well, I hadn't, but come on in now. Let's sit down and talk about it, and let's be a little more formal about this, and make sure that you didn't just give me some little off-the-cuff remark that I really need to follow up on here." So she should probably be thinking when he starts talking, and as she understands what he's talking about at the party, she needs to kind of be thinking about, okay, where is this going? What is he about to tell me? What are we doing here? And maybe she needs to stop him. I think I don't know about North Carolina, but I think the rules say that she has an obligation to tell constituents that she represents the company.
Yeah, so we can keep the ethical spin on the presentation. If you look at Rule 1.13, Section D, it makes clear that a lawyer shall explain the identity of the client when the lawyer knows or reasonably should know that the organization's interests are adverse to those of the constituents with whom the lawyer is dealing. And we're going to talk about some practical issues in terms of, well, how do you then conduct your investigations? But this is an extremely important component here to place employees in the organization on notice when you're outside counsel that you represent the organization.
And she may have gotten herself in a real tough spot because she didn't do that. And that's not that easy to do when someone starts talking. It's kind of hard to tell which sentence to stop them on. But you kind of have to be aware of that and be ready for it. Looking at, we're in 4A, I guess, now. Assuming that the associate Rogers believes the accounting practice is potentially improper and she's going to report it to someone, to whom should she report? We talked about that a little bit. A subordinate attorney, and this is under the Sarbanes rule now, under SEC Rule 205. A subordinate attorney is required to report to their supervisory attorney. So it's probably her team leader or the other person she's reporting to with respect to her work for Chemco, for the company. The team leader, let's say it's her team leader, the team leader has a duty then to keep going up the chain and to report to the to the group leader at the law firm at Dunn & Webb. And then Dunn & Webb, the senior partner at Dunn & Webb, who's the relationship partner for the client, probably also has a duty under the rule to report to the chief legal officer of the company. The chief legal officer is the supervisory attorney of this outside lawyer for purposes of the rule. So it's almost as if they're just in the chain, just as if they were in the law firm and a more senior partner in the firm. So the group leader, having learned of this, probably has a duty to talk to the chief legal officer of the company. And then coming back down the chain, the chief legal officer has an obligation to provide an appropriate response to the group leader, back to the reporting lawyer. And we'll skip, I'm going to skip a couple of these over here and we'll just kind of roll them in. So once the group leader reports it, the general, he can't just sit back and say, well, I've checked it off, I've reported. He's required to get an appropriate response. So unfortunately, you've just told the general counsel of your largest client about some horrible problem or potentially horrible problem. It's an unpleasant thing to begin with. And not only have you had to do that, you then have to wait a reasonable period of time and call them up and say, what's going on? What have you done? I need a response. I need to be told what you're doing. And the chief legal officer's got to provide this response. We're examining this. We're looking into it right now. I'll get back to you. We've looked into it. There's no problem. We've looked into it, and here's the fix. And the SEC goes through in the rule the actions that need to be taken, the remediation that needs to be taken. And it's arguably under the rule, you have to make a determination for yourself if you're that reporting group leader that the company has taken appropriate remedial actions, which is very difficult to do and depends on how close you are to the company and how much work you do, but that's kind of tough to do. Assume, just for a little sidebar here on facts, that the company has no in-house lawyers, that the CFO hires all outside counsel, basically manages the legal function, which really amounts to trying to make the lawyers cut their bills every month. So to whom does the group leader report then? I think under the rules, arguably it's the CFO. Every company has a chief legal officer, whether they know it or designate one or not. And if they don't have any in-house lawyers, they ought to be designating. They ought to decide, at least amongst themselves, and tell their outside counsel who the chief legal officer is, so that this group leader then knows this is the person to whom I report things like this, and you know that you've satisfied it, and you know who you look to. Here, under the state rules, would you go to the CFO? Would you go to the CFO under Rule 205? If you've heard what the associate has reported, has been told by Jones, would you go to the CFO as the chief legal officer? I mean, the rules tell you if it's futile to go, you can go to the chief legal officer and the CEO, but if that's futile based on what you know so far, you can go around them and go to the board or to something called a Qualified Legal Compliance Committee if they have one, a QLCC, if they've set one up prior to that time. And I think it's just obvious under the state rules that you wouldn't go to the person you think might be involved in the wrongdoing. You would have to go around that person. Now, the Rule 205 gives you some structure for that. The state bar rules, I think, Barry, would give you less structure, but probably about the same result. I mean, I think, that's one of the things about all the Sarbanes rules is they're very procedural-oriented rules. They give you, I think what the SEC probably thought was, people know the right thing to do. They don't seem to be doing it. So we're going to have to give it to them in a checklist form. We're going to have to tell them the procedure to follow, kind of like telling my kids, get your homework done, and they don't. And I say, okay, you didn't do that, so do this, then study that. And I think that's kind of what the SEC has done with these rules and with all the rules under Sarbanes for that matter. So I think one of the dangers under the rules is you have a lot more precise, detailed rules to follow than you do under the state rules. And I think, there's been a lot of debate about whether there's a conflict there, but I think they actually work together pretty well, and there's not much, there can be conflict state to state, but there's not that much conflict in the rules. It's just that the SEC rules are much more detailed.
Yeah, and again, we'd be talking there about Rule 1.13, which you've got in your handout here. And so I know that a lot of folks said that they don't work with publicly traded companies, and some of the Sarbanes-Oxley requirements that Mike's mentioning are more focused towards publicly traded companies. But we have a fairly strong mandate here in North Carolina in terms of bringing up information that comes to a lawyer's attention in which an organization is engaged in an action that may violate applicable law. It's not quite as detailed, obviously, as Sarbanes-Oxley, but I encourage you to take a look at that.
And as you know, under the SEC rule, the reporting out provision, the most controversial piece of the proposed rules, the reporting out, that you needed to report outside the company if you exhausted the inside sources, was not adopted. It was reproposed with an alternative method, and it's just standing out there now as a proposed rule. They haven't taken action on it, and they said they wanted to watch what happened, what people were really doing in the real world, and I think they're still doing that right now. Interestingly, under the North Carolina rules, if you put together 113 and 1.6, an attorney under the North Carolina rules, as opposed to the model rules, may resign if, despite their efforts within the company, no one is doing the right thing. They've gone all the way to the directors. No one's doing the right thing. I think the North Carolina rule in 1.13c says that the lawyer may resign. But I think in 1.6 of the North Carolina rules, the lawyer may reveal information from the client to prevent the commission of a crime by the client.
The ABA model rule has been changed, and it's spreading across the country now. North Carolina currently is considering modifying 1.13 to be like the ABA model rule, but we haven't done it yet. But you might point out that you should stay tuned and make sure that you've got current 1.13 for your state, because some states have adopted the ABA model rule, and some state are still with the rule we have now in North Carolina.
Yeah, that's a good point. And the model rule says the lawyer may reveal information relating to the representation if it's necessary, or to the extent necessary, to prevent substantial injury to the organization. If, again, having exhausted the internal efforts to stop the problem. So interestingly, under the current North Carolina rule, yes?
To ask a question, what if the company's response is to say, you're fired, lawyer, we're going to get us another lawyer? Does the lawyer's ethical obligation end at that moment?
Under Rule 205, it does not. The lawyer has learned of it in the representation during the time that the lawyer represented the company, and so that obligation doesn't end then. But there are interesting practical questions there as to, so you've been fired, you call the general counsel and say, I'm still waiting for that appropriate response. It's going to get tough to get. And so there are some real practical difficulties there. I know you fired me, but having reported this and gotten myself fired for it, you need to now send me a letter telling me what you've done about it. And the general counsel says, or what?
What's the answer?
And so under 1.6 in North Carolina and 1.13 as it now exists, you can't resign, you've been fired, but under 1.6 it says that you can reveal information to prevent the commission of a crime. So you have to then, I think, ask yourself, okay, is this ongoing? Are they going to report again next year, and they're going to show the public these bad numbers again? Is that a crime? If so, I can report out, I can reveal this in a way designed to prevent that. So you figure out how you do that.
Mike, if you're representing a small corporation in North Carolina, and your same exact hypothetical, except the information the young woman comes in contact with is one of the employees for the company says, I believe my boss is going to submit some fraudulent papers to the local bank in order to obtain a loan. Don't have the SEC rules or anything. All these rules still, how does it work under that? I mean, the rules still apply, don't they?
That's right. And so in here, if it's to prevent the commission of a crime, the lawyer could reveal the information. If it's a past crime, I don't think under the 1.6, the North Carolina rule, I don't think the lawyer could reveal that. So you have to ask yourself, has the damage been done and then that's it? Or is there something ongoing? And when you're talking about, in your scenario, you could, there's something's coming. You have reason to believe it hasn't occurred, it's going to occur, so I think you could try to stop it. You could reveal it. And you'd have to decide to whom and what's the best way and so forth. My point, I guess, is she would still go to her senior partner, their supervisory attorney, who would have the duty to go to the president of the bank or somebody and say, hey, it's come to my knowledge that you're getting ready to file some fraudulent papers, you got to mediate that. And I think that's right, and I think the rules don't tell her exactly where to go, so she's got to say what's the reasonable thing to do here, and it certainly makes sense to go to your supervisor or your superior within the law firm and get it to the right level at the law firm, and then do something about it as a law firm in that situation. So that's one of those cases where the SEC rule would give you the exact path with some choices along the way, but it would dictate it for you, and the state rules would give you more leeway and more general guidance. It's difficult, I guess, depending on your facts, which you'd prefer. Whether you'd prefer to be left to do what you think is reasonable and proper, or whether you'd rather have a checklist that you can hold up and say, I've checked them all off, I'm okay, I'm done.
Would the methodology change if the lawyer became aware of an external investigation for process crimes that may be being perpetuated at the same time, or is this purely substantive, in the substantive change? Meaning that the investigators are going to come down and sit down. The lawyer who heard this information, is she under an obligation to make sure that the client is telling the same thing to these external investigators?
There's an investigation that occurs after she learns of this,
Right.
that begins after she learns of this.
To prevent an ongoing crime.
Right.
You
Oh,
mentioned
okay.
the filing
Okay.
next year.
Okay.
What about a process crime in the course
Oh,
of the
okay.
investigation?
Okay.
I mean, I don't know whether that would extend to it or not.
I'm not sure. I don't handle that side of it myself, and I'm not sure. I'm not sure whether she could or not in that case. Interestingly, there's a situation. I guess it's still ongoing right now. I tried to get an update where an outside law firm was doing an internal investigation for a large company and was lied to by, I think, executives and other employees within the company during the course of their investigation, turned that over to the regulators, turned it over to, I guess, the U.S. Attorney's Office and the SEC, and some of those individuals are now they're considering anyway, prosecuting them for obstruction of justice for lying to the law firm when they knew or should have known that this was going to be turned over to the government. And that's the Computer Associates situation. So, I mean, that's, it was surprising to me. Now, I don't practice in the criminal area, but that was surprising to me that they were being prosecuted for that. One other thing to throw out here is we've got a whistleblower here. We have to be very careful. We've always had to be very careful with whistleblowers, now even more so with some of the new rules. There's a case in West Virginia. The first whistleblower case under Sarbanes is a small bank in West Virginia. I can't remember the town, the bank's name. It was a tiny, tiny public company. The CFO of the bank uncovered what he thought was some insider trading and some accounting problems. Went to the CEO and some of the directors, and those are the people he thought were involved in the problems, and told them so. And they didn't like that much. So they called him in. They asked him to come to a meeting with the audit committee. He refused. He said, "I want to bring my lawyer," and they said, "You can't bring your lawyer. We're concerned about privilege issues and confidential information of the company. So you can't bring your lawyer to our internal investigation and our interview of you." And he refused to come to the meeting. They fired him for insubordination. So he went under the whistleblower procedures under Sarbanes, went to the Department of Labor, and there's an administrative law judge ruling that sides with him and says that he was retaliated against for being a whistleblower. And so it makes you think a little bit more when you read the part about telling the constituents of the corporation when you're talking with them about something. You're required under the rules to tell them, "I represent the company. Don't be confused. There's a possibility your interests will differ, and I represent the company, not you." Do you stop there, or do you say, "You may want to get a lawyer"? Yes?
I have a question. The model rule and the North Carolina rule 1.13 limit that duty to report to matters related to the representation. I'm just wondering, in your experience of discussion, how broadly is that interpreted? I mean, the example we're using, it's probably related because she does some financial work for the company, but if she's purely transactional as an environmental matter, how do you determine whether or not you have that duty to begin with?
I mean, I think it's just all facts and circumstances. Is she working? Is it her representation? Is it the representation of her entire firm? Somebody in her firm may be doing the environmental. She may not be. She learns of an environmental problem. And so in that situation, I think you have to look, it's simply all facts and circumstances. Now, under Rule 205, under the SEC rule, it's learned while representing that issuer. So you can learn about anything, as long as you're representing that issuer and you are appearing and practicing, as long as there's an attorney-client relationship there. So interestingly, you can be representing a non-public client who's doing a transaction with a public company, and you learn of a problem at the public company. Under the SEC rule, you have no duty to report that. You learn that maybe their accounting is not quite so solid. You have no duty to report that. They're not your client in that matter, even though your client, that you learned of it because you were representing somebody in the transaction. This comes up with underwriters counsel in an offering, and they don't represent the issuer. They see a problem with the issuer, and that was actually broader in the proposed rule, but they tightened that in the final rule to make it clear that in those situations.
Do you have a question?
Oh, yes.
I think I understand that West Virginia case, and I'm not sure that I agree with your analysis of that case, because I think that the administrative law judge there said that they couldn't fire him for insubordination for not attending the meeting without his attorney. They didn't. I don't think they dealt with the whistleblower.
That they got to the retaliation.
Yeah. Yes. I don't think they got to the retaliation.
Well, you may be right. It's been a while since I've read the case, so you may be right about that.
I read that case recently, and I think that's the holding there, that they couldn't fire him for not being interviewed without his attorney.
For refusing to interview.
Right.
Well, didn't they then conclude that there was no reason to fire him, so the only reason he was fired must have been retaliation? That's kind of the way I read it.
Yeah, I thought they set it back, is what I think happened. But, I thought that was the reason that he refused to be interviewed without an attorney.
Well, I think it was. They said there's no reason to fire this man. He didn't, there's no insubordination. So why else did you fire him?
Right.
We wanted to get into a little bit on investigations and dealing with investigations, and so why don't we skip over to number 5 in the hypothetical, and just kind of go down to 5A. Assume that the associate didn't disclose. She didn't think it was a problem. She didn't disclose it. The SEC has launched a formal inquiry into their revenue recognition practices as they relate to booking sales through distributors. What are some of the, and they call the general counsel, and this is launched. What should the general counsel do the moment he or she hangs up the phone? What are some of the first steps? What are some of the first things to do when you go into sort of, emergency management mode there?
Yeah, I'm going to talk about what I call lessons from the battlefield, or otherwise known as I've got that T-shirt and it has holes in it. Things we've learned along the way, and I'm certain of Pete's experience and others who deal with clients who are in the midst of an investigation, whether it be the SEC or whether it be a non-SEC matter. A garden variety fraud case, or in my experience, I deal with Civil False Claims Act defense for healthcare providers. And the whistleblower issue has driven the Justice Department's litigation agenda for healthcare fraud over the past 10 years. Virtually all of the major healthcare fraud cases throughout this country have been brought by whistleblowers. And time again, when we go back and we do kind of retrospective investigations, it is always interesting when you can actually figure out who the whistleblower is, and you can trace it right back to the point that they raised the issue and the company didn't adequately respond to the whistleblower. The whistleblower felt that the company was sweeping their concerns under the rug, and they filed a Civil False Claims Act, and now the case is out of our control by virtue of the way an individual was handled. And I don't know if you do work in the Civil False Claims Act area, but the whistleblower, otherwise known as a relator, can get between 17 and, what is it, Pete, 33% of the recovery. And that depends upon whether or not the Justice Department will intervene in the case and take over the litigation, or whether or not they have to bear the burden of litigation on a going forward basis. So let's talk about some of the things that should happen on an initial basis. I heard Pete talking briefly when I was standing outside, talking about the fear. And so frequently at the start of an investigation, there is this fear and paralysis that will grip your client. Indecision, what do they do? What steps to take? Do they tell employees that they are under investigation? How do they communicate the information? In a case that I was working on in California about 9 years ago, we knew you can usually tell when you are under investigation because you will start getting feedback. An employee will say, I got a business card from an investigator. Little bits and pieces of information start coming to the attention of the company. And what do you do? And we advised this client, we said right then and there, you need to immediately put out communication to your senior management that all employees need to feel that the company will provide adequate representation to them, that they do not have to speak to government investigation officials, that the company will be happy to be present. And this company resisted, said we are not going to tell our employees, we don't want to create an appearance of that we've done something wrong. By the time that we had received the first subpoena from the Justice Department in that case, it appeared that they had already interviewed about 25 key employees. And we went back and we did the retrospective investigation of those employees. We heard uniformly and consistently that the employees did not know how to bring that issue to the company. They did not know that they didn't have that they could have said no to the investigator who showed up at their house. They did not know that the company would arrange for counsel for them. They did not even know how to bring that issue to the company's attention, even though this company, a publicly traded company, had a compliance program in place at that point in time, and these employees did not know how to access or use the company's compliance program. So one of the first things that I like to do is to begin a communication that goes out to all levels of the company, at least at a senior management. In a smaller company, that can be done in a boardroom. We just sit down. Some of the things that we need to begin to think about are document control and document management. Today, we live in an email world. The things that people put in emails never cease to amaze me.
They also never cease to exist.
We have to, I like to, and this is something I don't actually put in an email, I like to actually sit down with management and talk about the use of emails as soon as we're under a potential investigation and an issue has been brought to our attention. Things we should say, things that we should not. I have a presentation I go through things we've seen in document discovery in emails, and people are aghast at the things that people will write because they're very candid. Document control, destruction of documents will sink your case as quickly as a block of concrete. You will lose your credibility with the U.S. Attorney, with the SEC, if they have any flavor of document destruction. That's when the Ryder trucks pull up outside your client. That's when they take the documents and the computers. So one of the first things that I like to do is to take control, make certain that employees know what documents can be saved, how they should be saved, and how we gain control over that process at a very early on phase.
And I think if I could interject there, one thing that helps in that kind of a situation is to have a records management, a document retention and destruction policy in place that is well thought out, and they're not fun documents. They're not fun policies to draft. You have to go look in a lot of places to decide how long you need to keep a certain document. It involves looking at a lot of different requirements, tax and so forth and so on. But and it's one of those. It's almost a thankless task inside a large company. But if you have one in place that is well thought out and that is followed absolutely to the T for a long period of time, it's going to go a lot. It's going to help you a lot if someone destroys a document after the investigation someone was aware of the investigation. Maybe this person was not aware. And there's a question, should this person have been made aware? Were they aware? Did they understand what they were told? You know, Frank Quattrone comes to mind, and so if you have a situation where facts aren't quite clear, if this person is acting according to a slavishly followed document retention and destruction policy that is carefully drafted, I think it goes a long way toward showing there was no intent to destroy a document, to obstruct, or to do anything with the documents in the course of the investigation.
And the internal investigation is the logical next step, but I cannot tell you how many clients, either for cost control factors or fear, what does it mean if you're going to do an internal investigation, what type of signal does it send? They resist having outside counsel doing an internal investigation. And memory changes with time. And people's perceptions of facts change. And this whole story in this SEC thing in terms of revenue recognition here, I mean, the way it's written up right now, it appears, you don't need to know a lot about revenue recognition. It appears that there was something fraudulent. But I mean, there might have been some other underlying reasons. There have been some legitimate disputes regarding revenue recognition rules, even within the accounting industry in terms of timing issues. And so before it gets too far out of the gate, if you can convince your client to do an investigation and to interview the key employees, secure those notes, and begin that process, that will serve you significantly. If you then have to go before the SEC or the Justice Department, you've already taken some degree of control. Now, one of the things that I've given you in your packet, and this raises some ethical issues, I've given you a copy of an affirmation and undertaking regarding advance for legal expenses. This is a relatively simple agreement in which the company will agree to provide legal representation. First, a couple of points. You've always got to check with your state law. I think we did this one for a Delaware publicly traded company at one point in time. But if you have employees who are being touched, who are being called before a grand jury, I believe that to the extent possible, unless the company decides early on they're going to fish and cut bait, they're going to separate themselves from the bad actor. If there's any culpability in here, you look at this particular facts here, this is systemic. This goes to the corporation. Even if it's an isolated individual, the company may have significant securities issues, may have shareholder lawsuits, and this particular agreement deals with providing legal representation. Now, Michael will talk about the SEC's perception of how they are reacting in terms of when a company engages outside counsel. You will note that a couple of things that I've put in this agreement here, that the individual, when they sign this affirmation, if the company is going to provide legal representation, they are acknowledging they've acted in good faith, they've acted in a manner which they believe to be or not inconsistent with the best interest of the company, and had no reason to believe and did not in fact believe his or her conduct unlawful. We've enhanced this before, but what you will see is that the affirmation is set up so that should any facts prove to be the case, that they are the responsible actor, that the company would have the right to seek reimbursement for legal expenses. But my belief from a number of cases is that if the company does not provide adequate representation and make that commitment early on to the employees, and they end up being a witness or they end up being investigated without the belief that they have counsel, then again you lose control over the investigation. Now, justice does not always, this can create problems in a number of investigations. And Michael, you might want to talk about the SEC's perception.
Well,
in terms
we
of
understand the SEC considers it a factor in being cooperative as to whether you are paying for counsel for individuals who are under criminal investigation. They're voicing, apparently informally, I guess, concerns that that's a public policy issue, that they don't want companies reimbursing their individuals, their executives, people covered by the indemnification provisions and the typical bylaws when they're defending criminal actions. It's tough to separate. I mean, there's usually a civil and a criminal going on, and they're come out of the same facts and so forth. So it's very tough to separate and say, we'll pay for your lawyers for the civil piece, but not for the criminal. I mean, again, you may have a fact pattern that makes it a little easier to do that, but the SEC is taking a dim view of that, so we hear these days. Mm-hmm. And it's just another one of these. It's another of the factors of being cooperative and kind of going along to get along. And I think Barry's going to talk a little bit more about some of those factors.
This is a practical question. When you do provide attorneys, do the constituent employees find their own attorney and then you pay for it? How does that work?
Yeah, I typically find counsel that I feel that I can work with, that has experience, former prosecutor, particularly in a local area, that can be the outside counsel, and we try and structure the relationship so that we can share information and work together on the case until such time as there's a divergence. And that's what you're constantly on the lookout for in terms of when facts come to your attention that it no longer is in the best interest of the company to continue going forward.
Because that seems to play into Pete's question that he asked about, and the point he raised in his talk, is that you may end up, the company may end up okay on the substantive criminal investigation, and yet the employees who are participating in this thing may ultimately end up not being okay because of false statements or obstruction of justice otherwise. So it seems like a very dangerous area ethically.
And there is recent SEC enforcement action where exactly that happened, where I cannot remember the name of the action now, but they found that the company cooperated. The company gave up the individuals very quickly, cooperated, did everything, and the individual, I think two or three individuals were still in the suit, but the company they didn't bring any enforcement action against the company. I have, in at least one case, let an individual choose their own counsel, where it was clear from the beginning that the issue was not, the interests were divergent from the very beginning. And we have let them choose their own counsel and paid for it.
And that goes to the internal investigation side, because before I would consider engaging counsel, unless it's an immediate presence call before a grand jury, I want to get the investigation done. In a situation I was working on recently for a healthcare provider, we had a provider who came to their attention a sales representative had been fraudulently completing certificates of medical necessity, CMNs, for qualifying for patients, and that form cuts to the integrity of the claim form. And we went back and we conducted a very quick internal investigation within about a 72-hour period, and we decided that we were cutting loose from this employee, and we decided that part of our strategy was to move to a disclosure posture with the Office of the Inspector General through a voluntary disclosure protocol that they had, and we separated ourselves immediately. And the employee probably within a week had gone out and gotten their own counsel, and we were not paying for legal fees in that particular capacity. I think years past, we were very quick to immediately get counsel. Now we're trying to press for the investigation so we can make that decision, because if possible, it may not even be necessary to get outside counsel, because there may be no divergence. And to the extent you can represent all the employees, that would be ideal. But frequently you'll get a message back from the assistant U.S. attorney. I don't think that's a good idea, and usually that's a tip-off to me to say, why? Do you think that person is a subject of the investigation? And you usually get it could be going that direction. That gives me a signal for they know something that I don't know, possibly suggesting that I'm going to pull myself away in that particular situation.
I think we had a question up here. We had one.
Where you have a rogue employee, like in negligence, civil negligence law, of what you might call negligent supervision, whereby it was not so much that the upper hierarchy did anything knowingly wrongful, but simply failed to have steps in place to have adequate supervision of lower-level employees?
Sure. Bad internal controls, the books and records violation in the SEC's terms. I mean, and now with, again, Sarbanes, hate to keep mentioning it, but it is sort of pervasive. Internal controls is more important than ever. the sort of last piece of Sarbanes to be implemented is the Section 404 requirements that management design, implement, and test a system of internal controls, and then assess that in the testing, and then turn over the assessment, basically a report on their testing, to their outside auditors, and the outside auditors are then to test independently and determine whether they can sign off on the system of internal controls. And not having a system in place to control that could easily be considered a material weakness or a significant deficiency of your internal controls. The SEC has taken the position in a number of enforcement actions recently that virtually anything that goes wrong is somehow evidence of a bad internal control. Siebel has their second or third Reg FD, fair disclosure, selective disclosure violation enforcement action going on. The SEC has said in the enforcement action and the litigation release that one of the claims they're making is that that they had a material weakness in their internal controls. Otherwise, this wouldn't have happened. Somebody would have stopped this selective disclosure by, I think it was the CFO and the head of investor relations. Now, interestingly, we keep talking about Sarbanes, and I know everybody's thinking, I don't deal with public companies, I don't care. But lenders, your outside auditors, all kinds of regulators are looking to Sarbanes as, if not the letter of it, they're looking to the framework and the formality of that as a best practice. Delaware courts are already saying that some of these things are going to be looked at as best practices from a corporate law standpoint. And so it's important, I think, to keep a lot of these things in mind, even if you aren't representing a public company at that time. Was there some question over here?
What do you think about affirmation and undertakings that are conditioned upon cooperation by the employee with the government investigation? I mean, what about the ethics of that from the standpoint of counsel for the company and counsel for the individual who gets such a proposal that we'll pay your legal fees, but it's only in the case that you cooperate fully in the government investigation?
Mm-hmm. Well, some of these affirmation agreements, ideally they are looked at by the counsel who's going to be representing the employee, and this is a model, but I can assure you that they look very different sometimes by the time we are finished.
Who is a senior United States District in South Carolina, but Judge Perry was appointed by Judge Carter, I think, to be on the Court of Military Appeals back in the 70s. And he used to say, when I got appointed, he'd said, Walter, he has a very beautiful voice, he said, Walter, he said, the subject matter of that court is very narrow, but its territorial jurisdiction is worldwide. And so we would end up having to go to these conferences, CLE conferences in the Philippines and in Tokyo and in Heidelberg and places like that where United States troops, I don't know if anybody's doing any in Baghdad. I hadn't been invited if they are. But all of them have a common thread, and that is that the speakers who come don't get paid to come. They do it out of a sense of stewardship and out of a sense of professionalism. And so when we have people like Judge Horn and Pete Anderson and our distinguished guests and others that are willing to come here and share their time with you, it's just a wonderful thing. It's part of the stewardship of our profession. And I personally try to give back for that, and I hope if any of you have the opportunity to do it, you'll do it also. But this is a very unique panel. Of all the panels I've ever seen since I've been participating in all these, I've never had a father-son combination. And in this particular case, we have the Honorable Malcolm Howard, who is the United States District Court Judge for the Eastern District of North Carolina. Judge Howard is a graduate of the United States Military Academy and a graduate of Wake Forest, I believe, aren't you, Judge Howard, School of Law. And I got to know him through Judge Everett and through the Fourth Circuit Judicial Conference, and also because he actually sat with our court at West Point. We did a project outreach and had an actual hearing at West Point, and he was the judge that sat on the case and also authored the opinion. So if any of you ever want to read one of his appellate opinions, you can do so in the Military Justice Reporter. Just look him up. There's a good opinion. But with him on the program today is his son, Josh Howard. And Josh is an assistant United States attorney in the Western District of North Carolina. He's a Duke undergraduate and University of North Carolina graduate. And before I turn over the thing, I'm wearing an orange tie, Pete, but it ain't Virginia. without further ado.
Thank you, Judge Cox. I'm very pleased to be here today, ladies and gentlemen. I was in this building one time previous, and it was approximately 40 years ago. I think about 40 years ago this month. And I came in for the purpose of having a meeting with a dean-type person, I don't remember who it was, 40 years ago, in furtherance of my application to attend this distinguished law school. I had a very enjoyable 10-minute interview with that dean-type person and was very graciously carried to the door. About 4 weeks later, back in Vietnam, where I was posted at that time, I received a 3-cent postcard advising me that I had not been admitted to this law school. I hold no malice. I am glad to be back, and I come back today at the kind invitation of my esteemed colleagues and persons whom I admire greatly, Judges Everett and Cox, to discuss with my co-panelists white-collar crime. Now, I recognize my co-panelist by face and name, and hopefully by his soon-to-be accepted manners, yielding to seniority and authority. He sat across the breakfast and dinner table from me for approximately 18 years, and from the age he could speak, he challenged me and often his mother on about every idea or thought we proffered. He was a challenge for us in every aspect of life's development. Our parental counsel was his loving sister, who was 4 years his elder. She apparently understood him, accepted his needs and demands and activities, and as long as she or others provided sufficient pork barbecue and sweet iced tea, things seemed to go along very well. He would matriculate, as Judge Cox said, to this campus for undergraduate studies and then to law school, and I'm told has become an effective federal prosecutor. It would be my great joy to preside over a trial in which he was counsel. I would vastly enjoy hearing him have to say, "Your Honor, may I proceed?" I would conjure some way of denying this request. But for today, I recognize my co-panelist, a young, inexperienced, immature, wet behind the ear, fledgling federal prosecutor. And then I'm very proud to share this podium with my son, Josh, a dookie. Now, he's going to take the meat of the lesson, and I guess I'm like the bread, the sandwich that'll make it. After his presentation, I'll be happy to take on any of your questions. I will be happy to entertain any questions and give you some thoughts on such areas as the sentencing guidelines, as well as techniques of dealing with trial judges. One thing before Josh begins to further Judge Cox's theory and concern about the ethics aspect and to cover the ethics, just this past week, the American College of Trial Lawyers sent their code of conduct for pretrial conduct and trial conduct. In fact, the cover letter was dated October 16. That was 6 days ago, and it was distributing a copy of these codes to every sitting federal judge in the United States. In that, both the code for pretrial and the code for trial was endorsed by Chief Justice Rehnquist, and he said in his final sentence, "As Chief Justice, a former trial lawyer, and an honorary fellow of the college, it is pleasure to commend the code to the trial bar, law schools, and judiciary of our nation." There's one thing missing, and this is just a short story before we get again to the meat of the lesson. You notice Chief Justice Rehnquist mentioned as a former trial lawyer. He does not ever say a former trial judge. Think of our Supreme Court. There are 9 members. Who among those 9 members has ever tried a case? Chief Justice now, then Associate Justice William H. Rehnquist, had never tried a case and prevailed on his fellow members in the Fourth Circuit and ultimately the Eastern District of Virginia to let him come and try a case. He tried it in late 85, early 86, before he became Chief Justice, a year plus before. I forget the date when he moved from associate to chief. It was a civil rights case tried there in Richmond, a 1983 case. It was appealed. The Fourth Circuit brethren didn't know exactly what to do about it. They had heard a lot of rumors about the conduct of that 3 or 4 day trial. The panel consisted of the eminent Judge Donald Russell, Judge Emory Widener, and later Chief Judge Harvey Wilkinson to hear the appeal. It took them 6 months to write an unpublished per curiam opinion. Neither would sign it. I have a copy of it. He screwed it up so royally. He let the stuff in that should have stayed out. He let the stuff kept out that should have come in. Wilkinson, I sat at a dinner table some years ago with the 3 of them, and we discussed it, and the stories they can tell were hilarious. Wilkinson, being the brilliant judge that he is, didn't even discuss the trial aspects. He just took the case from its genesis and found how it should have been decided on summary judgment. Never mentioned the Chief Justice or the trial of the case, and totally reversed the case, and then remanded it to the district court, bypassing the designated Justice of the Supreme Court, to the district court to enter judgment in reversal for the defendants. The site is 813 Fed 2nd 401. It's unpublished, but you can find it. It's quite interesting. Finally, Josh Howard, I'm told an effective prosecutor is going to talk. Don't let him out of these hallowed halls today without asking him about another case that he was involved in the prosecution some years ago on. Before he became an assistant U.S. attorney, he was an assistant special prosecutor. And he was involved in a case of some note at that time. And there were allegations and very expensive investigations concerning such things as perjury, obstruction, and the like. And I believe he may have been in the room when that person walked. And he has the common title of POTUS. Ask him about it. Josh.
Your Honor, may I proceed? When I found my way into a job as an AUSA, he sent me a book that he had taken with him when he left the U.S. Attorney's Office, I think in 1971 or 2. 73, which he referred to sort of as the prosecutor's Bible. That was however many years ago. And when I started in 2001, that was the same book. What Pete Anderson spoke about earlier as the exponential growth of federal criminal law, I think has no more tangible form than that. But it is not entirely in the U.S. Attorney's Manual bureaucratic procedure. It is to very much extent a statement of policy and policy gained through experience. And for every U.S. Attorney's Manual, there are subspecialty manuals, narcotics, firearms. The tax manual is 3 binders of the same size. We, as AUSAs, do our best to follow those policies, but also, as all the presenters have earlier, we also find those policies tie our hands. And I'll talk a little bit about the Thompson Memo, corporate compliance, but since that's already been covered, let me tell you the best thing you can do representing a potential criminal defendant, be they corporate or natural persons, and that may be to help them earn a 5K downward departure motion under the U.S. sentencing guidelines. From the prosecutor's perspective, there are three key phases to the case. The investigation starts. I do almost entirely white-collar cases. That means we begin looking at it for months or years before any charges are brought. By contrast, we have very, very many drug and gun cases in our office, and my colleagues in those prosecutions have a case report from a Saturday night traffic stop, and the indictment would come down probably later that month. On the other hand, in white-collar cases, there is plenty of opportunity for attorneys representing putative defendants to come to the U.S. Attorney's Office and the specific AUSA and find out. The first thing you need to know, is my client a witness, a subject, or a target? I'll talk more about what that specifically means, especially for the folks who aren't everyday criminal practitioners in the audience. The next thing is what to do if charges are brought, if corporate compliance has failed, if trying to persuade the U.S. Attorney's Office not to bring charges has failed, how to best resolve the case, and thirdly, as we talked about earlier, or Pete Anderson mentioned earlier, the sentencing analysis, which can sometimes be very difficult. Now, with regard to witness, that's simply, someone, when I use the term, and I see there are other AUSAs here, that we use not necessarily to imply any criminal exposure. By the time they've reached subject status, we're still open, very much open, to listening to what the person might have to say to explain what they've done or what they know. But the formal definition in the U.S. Attorney's Manual is what you see on the screen. And by the time they reach target status, we need to have a sit-down. And I do almost entirely mortgage fraud cases in the last 6 months. I haven't indicted a mortgage fraud case in that period of time. Almost all of those are resolved after a target letter has been sent out and a bill of information which resolves all the criminal charges comes forward at the same time, all at the same time with the plea, and really the next court hearing for the client is sentencing. When the target letter comes out, you would hope that your client comes to you immediately. I have sent out many that we never heard back from. That is going to be an indicator if there has been some delay that we're going to be less willing to deal with that person, largely because other people have come in the door since that letter went out, and the value of anything they may have to offer is subsequently diminished. Pete Anderson already covered very thoroughly what happens when corporations get charged. As you see on this slide, we make the same analysis as prosecutors that we do in individual cases. Can we prove it? Would the jury listen to us even if it was proven beyond a reasonable doubt? And what civil resolutions would help mitigate the damage done? With regard to charging corporate entities, those again are the Thompson factors, or at least half of them. Pete has shown those, so I'll go through that quickly. And again, there are more factors. The adequacy of civil enforcement actions is very big with us. We spend a lot of time, especially some of the lawyers in this hall, sitting down, going through things that the agents from federal law enforcement agencies that brought the cases to us may not be aware of. We may not know there's a pending SEC action. We probably do, but we may not know of other satellite litigation that is going to make our case harder, especially if people have been deposed. And those are things that you can bring to us that the agents may not have thought to bring, that we may not be aware of, that make your case better, because some of the witnesses we were counting on may have given prior inconsistent statements that could very substantially affect our charging decision. Now, skipping through that, since that's already been covered very well today, for those of you who aren't everyday criminal practitioners, in my district, the Western District of North Carolina, over 90% of the cases are resolved through guilty plea. I spent a lot of time in front of Judge Horn doing plea and Rule 11 hearings where the defendant has not only come in to plead guilty, but very often agreed to cooperate. When they agree to cooperate, and I'll spend the bulk of my presentation on that, that's when, under the sentencing guidelines, and for those of you who aren't criminal practitioners, Section 5K 1.1 of the U.S. Sentencing Guidelines provides a mechanism which says, Judge, we know that normally, given the facts of this case, you would have to sentence within a very specific range which can be very difficult, as the judges and the defense attorneys have pointed out. But if the prosecutor says that this man has, or this woman has come in and helped the government's investigation, has told them things they didn't know, has furthered the prosecution of other people, or, and very importantly to me, explained to us why other people who might have been targets shouldn't be, we can try to tell the court that, make a motion under Section 5K 1.1 of these guidelines, which then opens the door for the judge to impose a sentence below that otherwise applicable range. Now, at the same time, if we go to trial, it's entirely possible you're going to get an upward departure motion. Same argument from the government the other way. This case is far more egregious than the standard case under the guidelines. Judge, you know the facts of this case. You know the facts of this person's background. You should go beyond the guidelines. I have much success in downward departure motions. I have not had very much success with upward departure motions in our district, and I have the stats that speak for the whole district later. And again, the guidelines provide a very standard reduction for acceptance of responsibility. Basically, the guidelines are an X and a Y scale, and on the bottom, running left to right, is criminal history. On the left, running vertically, is the offense level. And the guidelines take into account things that you might expect people to take into account. How much money was involved in the white-collar fraud? Did they use a gun? Had they held themselves out as a charity? Had they laundered the funds? Any number of enhancements to that offense level factor into the calculation. These are concerns you would hope a judge would take into account. They very formulaically mandate that he take that into account. And that is what has led, and I think you'll see statistically in a moment, to a much greater degree of consistency in federal sentencing across the nation. But if you go to trial, you're probably going to lose credit for acceptance of responsibility. And in very many cases, usually not white-collar cases, that may be all you can get. Our standard offer, for instance, in a bank robbery is going to be 3 levels for acceptance of responsibility. With regard to plea and cooperation, though, the downward departure is there, and again, I use so many bills of information. What I would almost always include in the plea agreement that go with that is an opportunity to come in and tell us what you know. However, we're not going to give you all the discovery that you might otherwise expect if the case had been indicted. Rule 16 hasn't applied yet. We'll show you the highlights. We're glad to sit down and say this is typical of the evidence we have against your client. But to some extent, they've got to make a leap of faith. They know what they did. They know that, probably through you, that we have a pretty good record of proving our cases at trial. And ultimately, we would like to not turn over everything in the pre-indictment phase so that we can use what we know to validate and to corroborate what this person's going to tell us later. This is a chart out of the 2002 U.S. Sentencing Commission federal sentencing statistics. That shows, especially for those of you who aren't practicing criminal law on a daily basis, that in a very recent 4-year period or 5-year period, what little room is left between everything pleading out and going to trial is about gone. 2.9% of federal cases in 2002 went to trial. This chart is from the same manual. You'll see again 2.9% at the top is the national average. Sometimes it's interesting to look at how district by district that can change. In the District of Columbia, there's almost twice that. In the Southern District of New York, which I'll talk about in a moment, there's a higher percentage. But if you look down at the bottom, my cursor's visible, those are the 3 districts in North Carolina. We all, and I'll get out of the way, we track each other in the rates of trials. Very few cases go to trial, and that is because there is a definitive advantage to coming in as soon as you can, pleading guilty, and cooperating with the government. What kind of cases go to trial when they do? I think you'll see at the top that murder, something subject to very, very heavy sentences, probably mandatory minimums, usually 20 to life or mandatory life, in a situation where, if if the federal government's going to bring a murder case, they're not likely to make very much of an offer. So you just as well ought to roll the dice. 20% of those are going to trial. You move down to fraud, and I think you can follow my cursor. That again gets back to tracking the national average. The significance of the fraud pleas, ultimately, unless you're in a more arcane technical compliance, intent to defraud remains an essential part of the vast majority of the charges we bring: mail fraud, wire fraud, bank fraud. And intent can be inferred from the evidence by the jury, but we as prosecutors would far rather have a cooperating witness speak to that intent of the person who's now on trial. So when we were asked to speak about the ethics of representing a client at trial, I would point out to the criminal defense bar that if you're representing a client at trial, it's probably not with he or she as a defendant, but he or she as a cooperating co-defendant who's going to testify at that trial. And what I want to focus on now is what you can do to best help your client earn as big a 5K as they can. In different districts, they call it different things. Very often we'll use an attorney proffer. In other districts, they call it a queen for a day. In our district, we use a lot of non-attribution agreements, which basically says we're going to have one sit-down, and it's off the record with a few limitations. What this does that's good for you is it avoids a situation where we enter into the plea and both sides expect that the government is going to be able to make a 5K at the end, and then something goes terribly wrong, and no 5K comes out, and everyone's disappointed. So the pro there is that we all know through that first pre-plea sit-down that we can work with each other. Or maybe we know that we can't, but it's good to know that up front. The drawback to that is that if the client comes in and is slowly coming around, but doesn't come all the way around, the FBI agent sitting there is very likely to make what they call a 302, which is the standard form report for that report of interview. And if they have not come all the way around on some things, then when they show up on the witness stand, one of the criminal defense attorneys is going to point out it was only the second or third or the fourth time that you talked about this that you got it straight. And that makes them a less effective witnesses, and less effective witnesses get smaller 5Ks. Now, the important thing that I would stress to criminal defense attorneys is that make sure then that before that meeting you have sat down with them and gone through it, and so they can say the fraud word. Time and again, you'll see clients come in and they are more, for us, they're defendants, they're more than willing to talk about all the bad things everybody else did, but they're not so ready to talk about what they did. Just as many people are willing to talk about everything bad they did, but they have this interesting trait where they won't speak ill of anyone else. The defendants have to come in and they have to buy into the process. We all have a human frailty that I'm about to talk about what bad things I've done, and I really hope this lawyer is right that this is off the record, because I don't want to get charged for this too. And it's important that they be disabused of that human frailty for that very first meeting. Now, the goals of that first meeting with us is to help us understand the case. Especially if it's pre-indictment. Is that back on? There it is. Especially if it's pre-indictment, help us identify other people that we may or may not know about, other people that we know are subjects but could now make targets. Identify key documents. I do a lot of mortgage fraud. I now know how to close a house, and I've never been to a Register of Deeds office. You're going to have to work us through that process, the key documents in getting a lender to loan money on a HUD-1 settlement statement. Tell us what it is about these deals, for instance, that we may not know about. Subsequent written side deals between the other co-conspirators. Tell us what to look for so we know what to subpoena. That's going to help you out when it comes for your 5K. Tell us, and you can spend time with your client to help them understand what kind of admissions they're looking for. It's always frustrating with a week to go before trial and you've been there 18 hours a day and you finally bring in a cooperating witness and they give you finally that time in the bar when the guy explained what he was going to do with all the money and where the bank account was. We get that too late to make much use of it, and that hurts your 5K. Another point, though, is if it's after indictment, Mortgage fraud, for instance, can be perpetrated in any number of ways. And in the indictment, we may characterize all of them as elements of the fraud. An inflated appraisal, a false loan application, a false settlement statement prepared by the attorney, payments made outside of closing to the buyers of the home. Well, some of these defendants may come in and they say, yes, we did 3 of those things. But, the appraisals weren't inflated. We would like to know that before we go to trial on the other ones. It may not be too late to supersede. It may be something that we're just going to disagree on, or that person, that client, was not yet aware of. Not all spokes in the wheel of a conspiracy are in on every part of the wheel. Finally, document production is fantastic. In white-collar cases, showing up at that first meeting with a box full of documents, the tax returns, the unstated revenue, can be very helpful. You'd be surprised at the number of defendants I've dealt with that after the agents came and searched their premises, then went and shred what was left. Those, as one of the presenters said earlier, those are things that strike not only to your credibility, but our willingness to work with you. The beauty of it, too, is that if you have a defendant, especially with criminal records, whose credibility, if they just tell the story, can be questioned, it's much easier to corroborate what they're saying if they also have the paper to back it up. And it's also helpful if the attorneys produce that to us in an organized form. It's, a banker's box is nice, a box full of files that explains to us in legal terms the nature of the fraud can be incredibly nice. Now, one of the issues with testifying co-defendants is that they're typically not attorneys. And the plea agreement we have in the Western District, and I think you'll see in most cases, says, I recognize that there's no telling what might happen with the judge and the guidelines, and that the penalty for bank fraud is as much as 30 years and $1 million of fine. And then they understand from their own attorney that given the amount of loss involved, I'm really looking at about 6 years. And if I get to testify at trial, then maybe I'll get a 5K, and they could cut that as much as 3. When the defendant hits the stand, it's important that they understand that. You can't build an education, a legal education into the client, I know that. But you can deal with them on how to react to those potential cross-examination questions. And as defense attorneys, you know how those go better than I do. But when they fumble with it, it makes it look like the defense attorney's argument is correct, that the government has bought this person's testimony with a generous plea offer. And the success of the government's case, once you've come in and cooperated, depends on effectively dealing with that cross-examination point. And I've always found it just absolutely best if the client will own up to the fact that, yes, they're interested in a downward departure motion. Very often they'll just say, no, I'm not here to get a downward departure motion. I just want to see justice be done. Well, with this guy's criminal history, that's not very likely. And so I don't feel that it's an improper coaching to make people own up to what they really feel. The next thing is this. The promotion now is that what happens in Vegas stays in Vegas. And that is true unless you're being cross-examined by the people that went to Vegas with you. And I have more often than I would like to have experienced had testifying co-defendants, people on our side, own up to things I had wished they had known before they took that stand. And so you as the counsel for this testifying co-defendant can help us out tremendously. If you'll find out in advance what all happened, what bad things that they're going to get cross-examined about went on, especially in the company of the guys that are still going to trial. And that way we can prepare for the response to that. It's usually drug use. Especially in white-collar cases, I have found that is one of the driving factors behind the fraud, was that it was to pay for drugs. They, as clients, have a human tendency to minimize their involvement in that. you can help them help themselves by having them come in and own up to that when they walk in the door. In the Western District of North Carolina, that is, again, from the Sentencing Commission's 2002 book, you'll see that out of about 572 cases, a third got substantial assistance departure motions at sentencing. It looks like other provisions of Section 5K, which provide for other bases for departure, such as sickness or old age or aberrant conduct, occasionally are granted. And it looks like we got one upward departure that same year. The interesting thing for the white-collar defense attorney in the Western District is maybe the prison term applied to fraud cases. About 58 of those 78 drew prison time, but it's not very much. 20 months, a year and a half is typically common in our district, and I think you'll see on the next screen, well, in a screen to come, that tracks the national average. When we make 5K motions to the judge in the Western District, we name a specific proposal. The pre-sentence report is something prepared by the probation office that goes through the plea agreement and tells the judge, you know, there was $5 million in loss in this case. That gets these many offense levels added on to the base penalty for that section. And then they add, you know, is there money laundering? Was there a gun used? Did they abuse a position of trust? That'll end up with a level, offense level 20, and that may call for 30 to 36 months, we'll say. If a person testified at trial in the Western District, it is not uncommon for us to make a motion to ask the judge to impose a sentence of as much as half off of that time. If you were short of trial as a witness, usually you won't get that generous of a motion, but we'll specify it. Other judges in other districts are not interested in that practice. Rule 35, to those of you who are not everyday criminal practitioners, is the post-sentencing mechanism that effectively serves the same goal. After a guy's already been sentenced, you can come back later if he continues to give good assistance to the government and reduce the sentence again through a motion to the judge. The most common textbook example of that is a jailhouse snitch. If the guy's been sentenced, he's in jail, and then he hears somebody talking about crimes that we can later investigate and prosecute, then a Rule 35 would be a great example of that. In other districts, where the docket moves very fast, sometimes that may be a necessary motion as well. A moment ago, I mentioned that in the Western District, the average sentence for fraud cases was around 20 months. I think you'll see on the bottom right that tracks the national average. Over 4 years, you'll see that the economic offenses has very slightly ticked up. Blakely came out, I think, shortly after this was published. We're in a bad way in the Western District right now with Blakely because in our plea agreements, we have we didn't know before the Blakely decision came out. And for those of you who aren't familiar with what it is the continuing, I see some people shaking their heads. Let me go over that then. The sentencing guidelines usually would have a base offense level. For fraud, it's typically 6. Depending on how much money was involved in the fraud, you can get an enhancement of that offense level from 6 to add, for instance, if it's more than $200,000, 12 points. So suddenly you're at 18. And then if there are more than 10 victims, but less than 50, you may add 2 more points, and that's 20. After you've given somebody credit for pleading guilty under acceptance of responsibility, they'd probably end up at offense level 17 and have a 2 to 2.5 year sentence. Under the Blakely decision, no one really knows what the continuing viability of the federal sentencing guidelines is. I have been out of law school a little over 5 years, and now that I know so much about mortgage closings, doing mortgage fraud, that may be what I have to go to real estate attorney school because the guidelines, which I know best now, may be out the window. But in the meantime, any enhancement that wasn't specifically charged in the indictment somebody pled to, such as 14 of those 20 points for the amount of loss and the number of victims, may not be something you can punish the defendant for, and they can walk out the door with probation tomorrow. So under the Blakely decision, I suspect you will see 1 or 2 year downturn in that bottom right column because the prosecutor's offices have some cases that were in the pipeline that may be incurable, and the only way around that now that we are pursuing is to charge virtually every count and every loss amount, and that's not fun for anybody because you end up with 200 count indictments when there's 200 mailings. One of the beauties of the guidelines before was that you could plead to 1 count, we'll call the full amount of loss relevant conduct, and then the judge can sentence the full impact, but right now that's very tenuous. Finally, that is just a chart that is the national breakdown of what's white collar and what isn't in federal courts for sentencing. I think the immigration chart, the immigration share of the pie in North Carolina is probably a little inflated. Ours is not that high. I suspect border states have inflated that nationally. And in our office, I suspect we do more drug cases than that. We certainly do more drug and gun cases than that. But that is it for me, and I'll bring His Honor back to the bench.
Blakely and guidelines, as Josh has mentioned, is very, very much up in the air. The case of Blakely versus Washington, Justice Scalia wrote the opinion for a 5-4 opinion, questioning and setting aside in the state of Washington the equivalent of guidelines. We don't know if it's going to apply to the federal or not. Now, there's those of you who do practice criminal law know, and others maybe a little bit. They did argue this the very first day of this session of the Supreme Court, October the 4th. I have not spoken to Justice Scalia since then. I do speak to him from time to time. He and Josh and I and his son-in-law, we hunt turkey three days a year every April. And he telephoned me just before the Blakely argument to see about the turkey season this year. And I did it, that was before the Blakely argument. I expressed my concern about it, that we were frustrated as trial judges. Remember, none of them have ever tried a case. And I think he understood it. He did say that we would have a decision by the end of October. Well, the date is the 22nd, so my calculation is he's got 8 days to produce. I don't know what. It's going to have a tremendous impact. If it throws out guidelines, what are we going to do with those cases that have been sentenced the past 15 years, 10 years, 5 years? I don't know. Anyway, we will wait and see. We've continued a lot of cases in the Eastern District just waiting for Blakely to come out, and we'll see where we go from there. Just a few other comments before we ask, do you have any questions? I mentioned this new code of conduct from the American Trial Lawyers College. There were a couple of them I wanted to go over. A lawyer should always show courtesy to and respect for a presiding judge, David Long. While a lawyer may be cordial in communicating with the presiding judge in court or in chambers, the lawyer should never exhibit inappropriate informality, Mr. Stubbs. A lawyer should avoid taking any action that is or appears to be calculated to gain any special personal consideration or favor from a presiding judge in a pending case. Now, that is difficult to ascertain what that really means. You know, people suck up to us. I know that. And it's done in a whole lot of ways. It's not by gifts over $50. I've been on the federal bench 17 years, and I never even had any intimation of a bribe or anything. But it's sucking up in other fashions. I don't even know what some of them are, and I don't want to go through those today. And then finally in that, there is one other thing, because the street runs two ways. During a trial, a lawyer should always display courtesy, dignified, and respectful attitude towards the judge, not for the sake of the judge's person, but for the maintenance of respect for and confidence in the judicial office. The judge, to render effective such conduct, has reciprocal responsibilities of courtesy to and respect for lawyers who are also officers of the court. So we owe it to you to be kind and maybe suck up to you a little bit now and then. A couple of quick stories. One has absolutely nothing to do with white-collar crime, but it's just interesting. My jury clerk we have in the Eastern District, we get two stories. We obtain the voter registration list from each of the 44 counties every 4 years. That all goes into a computer. And then we know that over the next 4 years, we'll need X thousand jury persons for Wilmington, Greenville, Raleigh, Fayetteville, and so forth. And that Mr. U.S. Attorney just came in. Frank Whitney from the Eastern District of North Carolina, the U.S. Attorney, ladies and gentlemen, standing at the back. Welcome him. Anyway, well, you haven't learned much in 4 years. Now that was unkind, and I just read. I am so honored you came. Anyway, Scott Cannon, our jury clerk, was telling me a story. This is truth. 10 days, 2 weeks ago, he had a call from this young lady who says, my husband is a Coast Guardsman. We live at Havelock, North Carolina, and he's been at sea for 30 days. And he just got in last night, and he has a summons to report for federal jury duty next week or something in Greenville to my court. And she says, he can't do that. We are trying to start a family. And he only has a 30-day leave. And the jury clerk, being a very alert and astute and biologically correct man, he says, look, we don't keep the juries overnight. Yeah. She says, you don't understand. We got to work at it all the time. That truly happened. Then he told me, Scott Cannon told another one this past week, that he had another fella call up. He says, well, I've got a summons to go to federal jury duty. He says, but I don't see why I got it. He says, I'm a convicted felon. And Cannon says, well, you can't serve. And he excused him. So then, what does our jury clerk do? Here is a convicted felon. We've got his name from the voter registration list. You can't vote as a convicted felon. So he calls Frank Whitney, or his office. I don't know what they've done about it, but little things like that crop up from time to time that are somewhat interesting. Another story or two. Lawyers, you're all lawyers. I'm going to quote from a final argument that Joe Cheshire and Keith Wiles, Keith right here, gave in a case in my court some time back. I think Keith wrote it and Joe pronounced it, but at any extent, the defendant was an attorney who was involved in an alleged conspiracy for bankruptcy fraud. But he said this about lawyers. This is Joe Cheshire, a criminal defense lawyer in Raleigh. And you know what, ladies and gentlemen, scares me to death when I defend a lawyer is that people hate us, and you know why they hate us? Because they don't know us. Everyone loves their lawyer. Everybody hates lawyers. If you have a lawyer, you love him or her, man, they're fighting for me, and that's my lawyer right there. But lawyers, they're all crooks. And that's what the government wants you to think. That was his argument to the jury. And I thought it was quite effective as he was discussing lawyers. I keep on going forever, but I want to talk to questions. And you didn't ask him that question I told you to ask him.
I'm not sure about that convicted felons can't vote, because there was a special recently on NPR that said that is a very common point of view, but that in many states, and I think North Carolina is one of them, convicted felons can vote.
Well, they're automatically restored to their rights once they complete their sentence, except for firearms. And
I've actually dealt with that in the last month, and a federally convicted felon, or I guess any convicted felon, can go through state superior court mechanisms to petition for the restoration of their rights. Mm-hmm. And that speaks to very many rights, including their voting rights. Mm-hmm. I think that might even get you a North Carolina right to keep or possess a firearm at your home, but it doesn't restore your federal right to possess firearms. but it does speak to voting, and you can either, whether it's an automatic restoration or if you jump the gun and go through the restoration process, get that done.
All right, what's your next question?
That was it.
All right. Let's talk a little bit about currying favor with the judge. That's what I'll term it, but it's really just effective defense work. How to help yourself a bit. We are fairly busy. In my case, I have at any point in time about 500 civil cases pending before me, probably 40 or 50 literally in the office with law clerks researching and writing on motions to dismiss or summary judgment motions. Additionally, at any point in time, I have about 200 criminal defendants in the system that have been indicted or charged and are awaiting arraignment, trial, sentencing, etc. So it's a busy operation with two law clerks. So if you are representing a criminal defendant, and then it's early in your career as a criminal defense counsel, file a trial brief with the judge. Make it just 5 to 8 pages. Lawyers have a propensity to file papers that are far too long. This is much more prevalent in civil work than it is in criminal, but the same thing applies in criminal work. Remember that old Baptist adage that if you hadn't saved the soul in the first 10 minutes, you're not likely to get him. The same thing goes with the long-winded paperwork and long-winded jury arguments. I particularly enjoy the current television program Law and Order. And I find Mr. McCoy to be far better than any of Frank Whitney's prosecutors, including Clay Wheeler, solely on this point. Mr. McCoy can cause to be investigated, indicted, tried, and sentenced all in 1 hour and take 5 commercials during that time. Now, Mr. McCoy's final argument awfully will only be 5 or 6 sentences long. David Long always wants a solid hour, and he bores the jury. Sometimes they go to sleep. That has to be worked on a bit by our profession. How many of you remember the name of the person who spoke just before Abraham Lincoln at Gettysburg that day? Anybody know his name? Don't say it just yet. I got 2. Judge, I won't hold you to it. What is his name? Mr. Everett. That's correct.
Not this one.
He spoke for 2.5 hours, like Buzzy Stubbs and likes to argue before the jury. And Abraham Lincoln, in 2.5 minutes, made a speech that has been chipped in granite all over this country. Think of that when you want to ask the judge to let you bore the jury to death. Another thing about trial briefs, motions in limine, get them on into us a week or so ahead. Typically, district judges have 2 law clerks, and typically we rotate. Law clerk A is handling this trial, and law clerk B is handling the trial week after next, and law clerk A again is the trial after that. And I like to have the jury charge actually drafted before we ever start the trial, because there's so many things going on once the trial starts. There's very little time for the judge to focus on that. And if you're kind to your jury, remember these people are coming in from their life's work, $40 a day and a cold biscuit. They are really being put to a great disservice. So we try to accommodate the jury far more. I'm not concerned about whether lawyers eat or drink during trial time, but the jury we're going to accommodate to the best of our ability. I'm doing all the talking now. If you have questions, raise your hand. All right.
I want to ask you a question.
Yes, sir. I figured you would.
What do you see in your courtroom as the trends of trials versus pleas?
About the same as the statistics Josh showed. They're under these guidelines. They're just unless there is really a question of intent, and intent is usually the case. There is so much to gamble. I remember the one thing on murder he showed that 20% of those went to trial. That was interesting to me. We have few of those. You know, the crime on a government land, there are a few from time to time, and that's tied up in a drug case, or it's crime on, in our case, we have in the Eastern District so much government land: Fort Bragg, Camp Lejeune, Cherry Point, the entire Outer Banks, National Seashore, Seymour Johnson. A lot of crime comes from those issues. We have another major issue facing us in the East. Mr. Whitney's worried about is there's bills to make the whole of Robeson County an Indian reservation, and that would become total federal jurisdiction, you know, and that would complicate a whole lot of things. What else you have, Mr. Long?
Well, what are you seeing by way of acquittals?
Acquittals?
Yeah.
We did have a hung jury about a month ago. That was the closest loss the government has had in some time with a hung jury. Now, I should also say that Keith Wells' client, they were totally acquitted, his one client there, in that case that he and Cheshire defended about a year plus ago. I can't think of any other. Frank, have you lost any cases recently?
We've lost 2 gun cases in 2.5 years. That's like maybe 2 out of 800 cases. I'm not sure. The drug cases, we might have had 1 or 2 defendants out of multi-defendant, but very few, about 99% conviction.
In white collar stuff, I've had several FEMA cases, FEMA fraud cases that resulted from the hurricanes and things like that, and there may have been 6 counts, and the jury may have found not guilty on 2 counts or something, but there's been some of those type things. But see, that doesn't affect the guidelines very much. All the relevant conduct still gets crowded in, and he or she gets almost the same sentence. This guideline business, I don't know exactly where the public is. The government loves it because, man, everybody goes to jail. They control it. All this 5K stuff, I have nothing to do with it until the motion is made by them. The defense bar hate it. They want to be able to go before a judge, and even though the man was caught with 5 kilos, he's a good Christian man, and he's found the Lord, and David Long would preach and sing and have all his family in there and ask for probation. Well, then the old judge, just human, he gets all caught up and starts to cry and stuff. So the guidelines protect us. I'm mixed about them. I don't totally dislike the guidelines. I recognize they limit my judicial authority. I recognize that the guidelines have long conflicted with the independence of the judiciary. But remember, the goal was to have parity between the sentencing of a bank robber in the Eastern District of North Carolina and a similar bank robber in Spokane, Washington. I think that has been accomplished to a large degree through the guidelines. Again, the guidelines were passed in '84. They really didn't get going until offenses in '88. My whole judicial career has mostly been with guidelines. However, I did have some old cases when I came to the bench, but I too was a federal prosecutor a long time ago, prosecuting moonshine cases and draft dodging cases, and there were no guidelines. And old Judge Larkins down in Trenton, he'd give them all probation. But if you stole money from the post office or out of somebody's mailbox, you went to jail. That was, and Buzzy clerked for him, and he knows that.
Let me say a couple things about the guidelines. The cases seeking the Supreme Court to resolve Blakely right now are Booker and Fan. They're joined together, and they've already been heard up there. I've read the Justice Department's briefs on that, and they point out what is on page 2 of this guidelines manual in front of me. The U.S. Sentencing Commission, which is who promulgates the guidelines, is an independent agency in the judicial branch. So the guidelines are not some harsh, draconian penalties foisted upon defense lawyers or defendants or anyone else by the Justice Department. They are brought in by the judicial branch to help them internally impose some degree of consistency. Now, there may be ways to improve upon that. And I suspect that's what we'll get out of Booker and Fan Fan. But they are ultimately something within the house of the judiciary, and by criticizing the guidelines, one should recognize that you're not necessarily criticizing the Justice Department.
We've talked about white-collar crime. I'm telling another story. And we've heard about all the list of white-collar crimes, false statements, frauds, mail fraud, and the like. I had one case that was tried to a jury verdict about 8 years ago. It was the case of United States versus Salvano Williams. Salvano was charged by the United States Attorney in the Eastern District of North Carolina with larceny of public money. I believe that was the title of it. What Salvano Williams did is he made his habitat in and around Fort Bragg, North Carolina. And he married Soldier A and started drawing the wife pension, or pension when the soldier went overseas somehow. He married Soldier B without divorcing that one and started drawing that pension. At one point in time, he had 3 marriages going on, and Salvano Williams was a man. He wore dresses and dressed himself up as a female, and the government actually brought this case to trial, and he was ultimately convicted by a jury, and that's a white-collar crime in the Eastern District of North Carolina.
Thank you so much. Thank you so much. That was great. Thank you, Josh. I'm going to answer the question that Judge Howard asked someone to ask Josh, but I'm not going to give you. I'm going to give you a clue. He was in the room with the special prosecutor, who was a Duke alumnus and a student of Judge Everett's at the moment that this historic event took place. If that'll give you a clue as to where Josh Howard was, you could.
What they're talking about is when I finished law school, I clerked for a judge, and then I went to the independent counsel's office in Washington, the Kent Starr office for Whitewater and Monica Lewinsky. And as the story goes, I don't usually wear bow ties, and that was inauguration weekend in Washington. Bush had just been elected. Clinton was on his way out, and I was the new guy. Well, nobody bothered to tell the new guy that today was a big day. So I just walked in the office like I normally did. It was casual there. And I had brought a bow tie so that someone for one of the inauguration galas could teach me how to tie it. Well, as I'm tying it, the independent counsel, Bob Ray, who had succeeded Kent Starr, came by and decided for that moment he wanted to have the new guy. So there I am in a bow tie, which I don't normally wear, and a ragged blazer that I used to wear to fraternity parties at Duke. And I walk in the room, it's David Kendall and the independent counsel, and they are about to sign an agreement not to prosecute President Clinton upon leaving office, but rather that he would sign away his Arkansas bar license, and I think as a result, his Supreme Court admission. And I am proof that if you find an old Washington Post article where I'm standing behind the independent counsel in the only bow tie I own, that you can work out a deal with the U.S. Attorney's Office or with the prosecutors. It might not be where we'll walk away, but we would decline criminal prosecution in exchange for another penalty. Now, I've not worn a bow tie since, and I haven't declined a case since, but there is one.
Thank you very much. That was a unique experience, having Father Son appear here. Our last 2 panelists, I'm very pleased that they would come and share some what Jim Toms describes as troubles. I first met Jim here at Duke University. He was a student of Judge Everett's, I think, class of '68.
Yes, sir.
Jim. And he was a very successful and prominent plaintiff's attorney involved in a lot of major cases. And he found himself in a very difficult situation with client funds and turned himself in and faced the consequences. And he is now helping teach young students here at Duke and other places how to avoid those problems. I have not had the pleasure of meeting Mr. Tomlinson, but he is an acquaintance and friend of Judge Horn's, who faced a very unusual experience of actually, maybe, are you going to talk about your experience? Well, I'll let him tell you the experience rather than me trying to paraphrase it. But Dick and Jim, we're most appreciative that you would conclude this program today by telling the lawyers what it's like to be on the other side and what things we can do to make your life easier along the way. Thank you.
Thank you. Thank you very much. I am Dick Tomlinson, and I'm probably the only person you'll ever meet that was driven to prison by a federal judge, and who's a very close personal friend. Now, I enjoyed the ride a lot, and I enjoyed the conversation. It's just the layover I didn't enjoy very much. The invitation for me to be here at Duke University today was predicated on the fact that I was charged with a felony. Now, I sincerely hope that that is obviously not the same reason any of the rest of you are here. The United States of America versus Richard Tomlinson. What a horrible, horrible piece of mail to get, and what a terrible thought. I actually envisioned 285 million people in the United States coming after me and really disliking me, but what a power the government has. After 30 years of raising 5 children, being a businessman, active in the community and my church, I found myself in the following series of situations. Corporate bankruptcy, followed by personal bankruptcy, followed by indictments, which led to divorce, which ultimately led to incarceration in a federal prison. Heck of a series. But it didn't have to be this way. If I had only known better, and if I had only planned better. As a consequence, I learned some valuable lessons, expensive, damaging, that I hope I can share with you today so that you can share them with your potential or current corporate clients. If you look up the word naivete in the dictionary, you'll see my name. Let me illustrate. When I was first contacted by 2 special agents from the FBI and the IRS, I was so convinced I had nothing to hide that I told them I'd pick them up at the airport and buy them lunch. When you're on that side, you'll find that's not what they had intended. Kind of goes back to something Josh and Pete said. There was no idea in my mind whatsoever that I had anything to hide. I brought my corporate attorney to the initial meeting with the agents, and the one thing he did know about criminal proceeding was to ask if I was the target of the investigation, to which both special agents said no. Later, when it was too late, the FBI agent claimed twice that he did not say this, then finally admitted under oath that he did, without any adverse consequence to him or the Bureau. Ostensibly, they claimed the single purpose of our meeting was for me to aid them in finding my ex-partner who had disappeared about a year earlier. I said, no problem. The critical moral at this point was we did not know to request immunity, since I was supposedly not a target of the investigation. Next, on the same visit, they asked if they could access all my corporate files, many of which were in my attorney's office since I was in bankruptcy. If you can believe it, my attorney and I once again said, no problem, and promptly took them to his office and opened all the files for their investigation. An enormous and costly mistake I made, therefore, was taking my highly credentialed corporate attorney, no offense, with me on this initial contact with the agents. I didn't know his limits as it related to criminal law and have paid heavily for that decision over the past 12 years. The statute of limitations is 5 years for the crime I was to be charged with, and after 4 years and 364 days had transpired since the purported criminal act had taken place, I was finally charged. It is only then that I decided I needed a good criminal attorney, which was well after I had given free access to all my records and had failed to request immunity. I can't say that loud enough, and I can't say it clear enough. We had failed to request immunity after they said I was not a target. I was indicted, along with 3 other men, on the charges of conspiracy to commit mail fraud. And when I read the indictment, I had no idea what this law of conspiracy was all about, but I was certainly about to learn. Conspiracy, in my humble opinion, no offense, is a prosecutor's mother lode. Broad and sweeping, it casts a net that can have varying degrees of substance and relevance, but is enormously powerful. In my case, there were 4 people indicted: the principal source of the scheme, who was my ex-partner, 2 sales agents representing him, and myself. The other 3 men had all been tried in a civil case several years before and were found guilty in order to pay significant restitution. However, later, when the federal government began investigating the entire matter, they utilized the power of conspiracy law to move toward indictment. As soon as the other 3 were advised that their civil proceeding was now to have criminal charges, they sought advice wisely from criminal attorneys as to the likely consequences. They then proceeded to plea bargain agreements with the government, naming me as a primary planner and therefore as a co-conspirator. By doing so, they benefited greatly by being the first to plead and shifting the blame. The biggest lesson I learned from this was that if you associate with people who stink, you're going to carry the smell too. Make no doubt about it, the sins of your associates are, by conspiratorial definition, yours as well. Say that one more time. The sins of your associates, by conspiratorial definition, are yours as well. In court, the U.S. Attorney stated, when referring to me, that even though there were no direct ties to my having illegally solicited funds from the public, which I had not, that by virtue of my education and business background, I should have known there was an impropriety going on, and that in and of itself made me a co-conspirator. Both these gentlemen mentioned that earlier. I should have known by virtue of your background. Under the federal sentencing guidelines, going to trial is just too great a risk to take. I was faced with what I felt was a lose-lose proposition. First, the U.S. Attorney had gone to the grand jury and procured a series of indictments, and I was not aware of their actions and was not represented at the hearings. Once they were handed down, I was advised by the government that something like 95 to 98% of persons indicted plead or are found guilty at trial, and Josh's figure showed the exact same thing. Therefore, my choices were 8.5 years in prison if I went to trial and lost, or plea bargain for up to 3 years to 1 count of conspiracy to commit mail fraud. To illustrate an even greater discrepancy, the Wall Street Journal recently had an article wherein a man was charged with possession and distributing marijuana, first time, had a gun, and was given 63 years without parole as he chose to go to trial and lost. He had been offered 16 years as a plea bargain, a staggering 47-year difference for contesting his rights in a court of law. The risk to me was absolutely overwhelming, and I pled to the single charge. Next lesson I learned: do not antagonize the government. I had 2 criminal attorneys. The first was in Charlotte, North Carolina, my residence, but the charges were brought in the Middle District of Tennessee, where my ex-partner ran his business. Initially, my Charlotte attorney told the government that under no circumstances would we deal with them or even meet with them to discuss the matter, as I was innocent and I was going to trial. The government was not pleased. When our request for a change of venue was denied, I had to hire a co-counsel in Nashville who immediately suggested a meeting with the government. When we finally met, the meeting atmosphere took on the air of just having slugged a hornet's nest with a baseball bat. It was ugly and didn't improve much over the next 12 years. There was no cooperation whatsoever on requests for downward departures, for reduced active time, and ultimately I received what turned out to be an excessive restitution. Therefore, folks, I was prison bound. Incidentally, the appellate court unanimously overturned this part of my sentence after my release from prison, and had the appeal been heard prior to me doing the active time, it would have obviated me going to prison because the restitution was lowered by 97%. I learned some very important lessons from my active sentence. Prisons are not nice places. And you don't necessarily meet the kind of people you want to socialize with the rest of your life in there. To some degree, prisons are run by the most powerful drug dealers who go to school on each other and refine their skills to go on to bigger and better deals upon release. They represent one control group, and the other control group is the guards themselves. And I can assure you that the control criteria for those two groups is quite different. Incidentally, you're likely to meet a few lawyers while you're in there too, which I did. When I first entered prison, I was stripped down, given a time-worn uniform, and was ushered into my dorm. I looked around at the four walls and the 71 sets of eyes staring at me, knowing this would be my home for the next couple years. I became profoundly depressed. I was so depressed on the spot that my chest hurt, my stomach was sick, and I just didn't know what I was going to do. I never felt so isolated in the middle of a crowd. I went into the bathroom, pulled down the toilet seat, sat down on top of it, and although I thought I prayed pretty heavily all the years leading up to that, that's about as hard and sincerely as I ever asked the Lord to help me. And to my benefit, He did. It was almost like lancing a boil. I got immediate relief, and thank God for the next year and a half that I spent there. He gave me comfort and satisfaction the entire time. In a recent interview with Larry King, Martha Stewart was asked if she had spoken with Sam Waxel since he had gone to prison. She indicated that she had talked to him once, and he stated that he had read, now mind you, he just went to prison this year, 180 books already. My guess is he'll be in the 3,000 to 4,000 book category by the time he gets out. And you folks thought you had a lot of reading to do. I too survived by reading and doing some creative writing. Every day I would begin with an hour of spiritual reading, very early in the morning. Then during the course of the day, I would read some philosophy just to challenge my mind. Every day I'd read some criminal law, because I figured it was about time I learned about it. And finish with a popular novel in the evening just to put me to sleep. I followed this routine of reading 4 different types of information every single day that I was incarcerated, and it helped me immensely. Now here are some of the lessons that I learned to be shared with your corporate clients. In their business associations, within their corporation, and with those with whom they deal, never, ever let your guard down as it relates to suspicious activity. Going back to, you should have known. Be like the 16-year-old who just got their driver's license. Extremely alert, very careful, and extraordinarily observant. It is only after time has passed and we become comfortable with our surroundings and our environment and our associates that we become exposed and vulnerable. Make it their business to always know what's going on around them and who is doing it. Remember, not being a direct participant in a fraud will not necessarily eliminate them from a conspiracy charge. If you take anything else, any other message away, that's what I want you to hear. Not being a direct participant in a fraud will not necessarily eliminate them from a conspiracy charge. Choose carefully those with whom they work as much as possible, and those with whom they socialize as well. People can be very different in separate environments. Should they ever be asked to participate in an investigation, be it criminal or not, it is essential for them to seek and gain advice from a knowledgeable criminal attorney and follow that advice in an absolute way should they feel an exposure. Remember, many civil inquiries can quickly escalate into criminal charges, and it's too late if the exposure is already potentially damaging. Remember Martha Stewart. Remember obstruction of justice. And remember my comments earlier about ushering in the special agents well in advance of getting any kind of protection and discussion with a criminal attorney. I was exposed, they had everything, and it ultimately was very damaging. Insist they be totally honest with you, their attorney. Neither of you want to wind up having their testimony impeached on the stand, killing your case or adversely affecting your plea in the ultimate sentence. Carefully research all their options, that is, the probability of certain outcomes and the respective impacts on themselves, their businesses, and their families. Cooperate with authorities after you, their attorney, has approved the meeting and brought in any necessary additional assistance. Know as an absolute fact that in a conspiracy charge, the others charged will cut a deal as fast as they can, limiting their exposure and increasing your client's exposure. By definition, one man's opinion, the system is constructed to reward the first person in with the best story. And finally, on a personal note, hubris, an exaggerated opinion of your own abilities. Don't be a hero when it comes time to give counsel to others. Make sure you are accurate and timely, and double-check your advice with more seasoned, specialized counsel. Ultimately, you and your client will be much richer for the experience and not have to suffer the unnecessary consequences. Thank you very much.
Thank you, Dick. It's a special privilege to be able to end our session here today. I hope that some of my experiences can be of practical help to you as you advise clients, as we focus on some of the personal things that can go wrong with your clients, and as we focus on some of the personal things that went wrong in my life that led me to tender my license back to the bar and submit to a course that, as an experienced lawyer, I knew would require my imprisonment in order to have any opportunity to clear the books and to potentially redeem my record. Let me just say for a moment to my sincere apology to you, my former colleagues, who I let down in failing to follow the ethical standards expected of me, and in bringing the profession that I believe I served well for nearly 30 years into disrepute. It's important sometimes to recognize the things that you can control and the things that you can't. And particularly it's important for us, in my former capacity as a member of the bar who loved the law and loved the work of lawyers, to recognize what goes wrong and why things go wrong, and identify the things that are going wrong in your own life and do something about them. It's particularly important to recognize the need and the reason for the ethical limits that prescribe what lawyers do, and so that you do not develop a dichotomy between what you are capable of doing for others and what you let happen in your own life. It's so easy to think of the good you're doing for so many people and the benevolences that you're involved in and the political good you do and the success you have, and suddenly you realize that there are feet of clay and that the problem is great enough that only a very serious readjustment will solve it. And that's exactly what happened in my situation. I knew that I was in serious trouble and came forward and disclosed it. And looking back on the course which was somewhat painful, I know I did the right thing at the right time, and I am the better for it, and I hope that from the lessons I have learned that the profession I loved is the better for it as well, and particularly the young people that I'm able to work with. There are lessons that I learned along the way that are relevant to your other type A clients, your strong personality people that have been talked about at such length today. And let me just share some specific points and then also talk a little bit about some of the bad results I've seen in the time that I served imprisonment in our federal prison system. First, it's so important that if you see serious trouble coming, whether it's yourself or your clients, that you deal with it straight up. You deal with it yourself. You don't let the situation fester and get worse and get worse and get worse. Even the most unpalatable news is better disclosed than found out. Secondly, clearly accept responsibility unconditionally for what has gone wrong, and do not provide windy excuses. Your friends don't need to hear them. Your enemies won't be pleased. Thirdly, if you are representing a white-collar client in trouble, or if, God forbid, you are a potential white-collar target, recognize that the psychological effect on the client of the loss of perceived status is going to, in many instances, affect the clarity of thinking of that individual, so that they may not think clearly about what the risks really are and what the appropriate course is that should be followed. It may be that you need to bring in other people to help you. What a good friend of mine in the bar used to refer to as senior counsel, by that not meaning lawyers necessarily, but a pastor or priest or rabbi, or it could be a clinical social worker or a clinical psychologist, or just a good family friend, someone who can help that individual see through what needs to be done and develop the courage to do it, even if it's painful, particularly when it comes to one's own view of oneself, how you're perceived by yourself and how you're perceived by the people around you. Remember that one of the initial Enron executives who disclosed the problems at Enron took his own life, and he was one of the good guys. But the loss of perceived status, the economic losses, the stresses that went on were so great that he took his life, even though he probably would have had, if prison time at all, a greatly diminished time. But somewhere along the line, he did not have the resources that perhaps he could have been given to handle the depression, to handle the stresses that were involved in that very tragic situation in Houston. Now, let's take those points and shift over just for a few minutes to the handout. If you look at the handout with the first page, corporate crime proposals, these statistics are from ABC News from the year 2002. I have reason to believe that they still are valid, and this affects, I think in a very personal way, the perception of how the public looks at the white-collar crime increases in guideline ranges. And you'll see on the first page that 54% of the Joe and Josephine six-packs in the country didn't think the president's proposals were tough enough. Look on the second page and see that while 63% of these polled believed their own employers' executives, only 11% believed corporate executives in general, and 16% believed corporate financial reports, though 73% believed their own employers' financial reports. If those statistics remain valid, and I believe they do, there remains a wide dissatisfaction on the part of the population of this nation with what has happened in the savings and loan industry, the insurance industry, the whole range of corporate misconduct and false financial statements, the drops in market capitalization and the like. And I don't think we're anywhere near the end of that cycle of the pendulum shifting toward harshness from where it might have been a few years ago. And I simply suggest to you, keep that in mind as you both advise clients and also as you perceive what government will do, because I think we can fully expect a response reflecting in part public opinion. Consider that we are in such a narrowly split nation right now in terms of the election, where just a few percentage points separate both national candidates. I think it's obvious that a strong anti-white collar crime position is something that is a given in this particular day and time, and so keep it in mind. The second item is a Fourth Circuit case, U.S. versus Bolin. I want to call your attention particularly to the defendant who is the lawyer, James Gormley. And I've copied this opinion for you because it's probably the classic illustration of how not to handle white-collar criminal exposure if you're an attorney. Let me tell you just a little bit about Jim Gormley. I met him at the Butner Low Security Correctional Facility when he came in the law library one night and introduced himself. I was the law librarian, the inmate librarian. I was getting ready to leave for Seymour Johnson Camp, and Mr. Gormley had just arrived and had heard it was a good job, and so he came by to meet me. I should have realized that something wasn't quite real in the sense of his acceptance of reality when the first thing he did is introduced me and stated where he went to law school and also where he went to prep school. And both were distinguished schools. And I looked around the room. I had maybe 20 men in the room, most of them Latino or African American or foreign nationals, desperately trying to read law books and come up with some way out of what was, I'm sure, bad results for them. My task was to hand out the books and show them a little bit about how to shepherdize or some of the basic things they needed to know. And I thought to myself, this fellow doesn't really understand where he is or what the nature of his community is if it's useful to him to tell me where he went to prep school in this place. Well, I did recommend him for the job, and I went on the next week to camp. I later learned that when last heard of, he was on the bus for Milan, Michigan, what we call colloquially a diesel therapy, where a person who has a situational adjustment is put on the road to some other place, and the trip might take a while. It's sort of like the old Kingston Trio song about the MTA, you know, will he ever return? No, he'll never return. His fate is still unknown. So this man didn't, in that setting, understand where he was. When I read his case in the advance sheets in the Fourth Circuit, I saw more specifically what had happened to him because I stayed carefully out of people's cases, didn't show that much interest and to stay away because you had so many people with bad results there would be no end of the questions. But in reading the opinion, you'll see that Jim Gormley represented classic scamsters, the old London interbank investment scheme where gullible investors, typically doctors as these investors were, are induced to put money up in six-figure numbers to be turned over to the scamsters, and the money is supposed to be collateral for investments that are then invested on the London market. Of course, there's a gem of truth to that, a little bit, just a tiny bit of truth there are investments on the London market, but of course the problem is these particular scamsters were paying off the later, the first investors with the later investors' money, a classic Ponzi scheme. You'll see in the opinion that Mr. Gormley was visited by an FBI agent who said, your clients are scamsters. And in a fundamental problem, he ran the agent off and said, no, they're honest businessmen. And at that point, he's named a target. Now, add to the equation, here in the Fourth Circuit, if you're an Atlanta lawyer, you're out of the circuit, and you're representing people on international financial matters, but you went to a prominent school in the circuit, and you consider yourself sort of a Brahmin, if you think it through, one of the least hospitable places for you to be indicted would be, well, Southern District of West Virginia. And you can be indicted any place there's a victim. So that's where the trial occurred, as you'll read in the opinion. And he didn't do well. He got a very long sentence. And one of the things that happens in the opinion is that the court deals with an issue that he raised on appeal, and that was that his trial counsel did poorly because they argued to the jury that they shouldn't hold against him the fact that he was obnoxious. And the opinion says not only is that a reasonable exercise of litigator's skill, but we've read the record and he was. And I've met him and he is. So, you know, he also helped illustrate the maxim that hard cases make bad law, because this case stands for the proposition also that the forfeiture law, the federal forfeiture statute, trumps the Georgia state exemptions for IRAs. So not only he lost his IRA, and there's not a lot of law on that. There wasn't a case in the Fourth Circuit, but his obnoxiousness, I'm sure, helped that Fourth Circuit panel decide to not let him get away. Notice also in the opinion that the people who got the money absconded. They left the jurisdiction, except for one who testified against him. And you know, the scamsters either ran or had the good sense to plead, and left him holding the long sentence. It's a good one to study and to think about, because it does affect one's professional exposure, and it's a good illustration for the behavior of clients as well. Look next at the Charlotte Observer story about a similar factual situation to the Boland case this past spring that resulted in a sentence against bankers in Rock Hill, South Carolina, in which the sentence was far lighter, but there was cooperation. And actually the losses were comparable. Whole different scenario. I won't belabor it. We've talked about it. It's already been discussed at length today, but a good thing to compare what has been done. The third page, a column by Rob Christensen of the News and Observer about the problem in perception that, from Rob's perspective, affected Meg Phipps' view of what was going on. And of course, she is a Scot, and all of us who grew up in North Carolina knew her family well and supported both Governor Scott. I heard my father speak so highly of Carscott and how he brought roads to the West. But yet, she was dangerously close to having her circumstance boxcarred, that is, having sequential, non-concurrent sentences. And I know as we watched her case from here at the law school, as I was working with Judge Everett's students, and she was one of the case studies that semester, I was telling the students, I hope she'll come to the light and realize that she can't make it work this way. You know, she cannot try her case. She cannot send her father across the state to threaten the governor and say if only the state officials would back her, that it'll all work out. It just wasn't going to happen. Again, there was, I would assume, a lack of consciousness of reality, of what she was really facing and what was really going on. And Rob Christensen speaks to that. The next story about Frank Cotrone's sentence above the guidelines for obstruction of justice that's already been discussed in an earlier presentation. Keep that in mind. I think it's helpful. Then the final opinion is one from the U.S. Court of Military Appeals. You will see three familiar names. You will see the authoring judge, who is loaned to that court by the D.C. Circuit. And that particular judge is well known to all of us here in North Carolina, but I see two other names on the opinion concurring who are also present in this room, Judges Everett and Cox. I want you to see on page 15 of the opinion particularly, and on the underlined section on page 16, the portion dealing with ineffective assistance of counsel, because this is the only reported case I know of, particularly that could be useful in North Carolina, because we've got both David Sentell writing the opinion and we have Judges Everett and Cox concurring that bad advice by counsel with respect to plea negotiations may constitute ineffective assistance of counsel. In this instance, the civilian attorney of Marine Sergeant Lone Tree obstructed his dealings with his military counsel, and interestingly enough, his military appellate counsel was here speaking at the law school just a few weeks ago, and made it impossible for this individual who had been a guard, you may recall, at the U.S. Embassy in Moscow, was compromised by a Russian undercover agent, but made it impossible for him to work out a plea bargain that would have saved him substantial imprisonment. And the court sent the case back for an evidentiary hearing on whether or not he should be provided a new sentence. And ultimately his sentence was reversed and reduced substantially in those proceedings. I share the case with you because it may be helpful in terms of focusing the counsel's responsibility to effectively deal with the opportunities of settlement of these matters. The hour is a little late. I don't want to belabor what I've got to say, but let me just open it up if you have any questions for me about things I have learned or comments that you might want to make about what Dick Tomlinson and I have presented today.
Jim, maybe you could share your thoughts briefly on the inadequacy of counsel, what counsel can do about the post-trial, what happens to their clients. I know as an attorney, I had a little understanding of what was going to happen to my client. Is there anything that we need to know? Is that helpful in any way?
It's most helpful. You can make a huge difference. Remember, once a sentence is imposed, the authority over the prisoner goes from the Article III courts to the Article I Attorney General by statute. So the Attorney General has custody of the inmate. Thus, even though the judge may recommend a place of confinement, the Attorney General, through her agency, the Bureau of Prisons, is not obliged to follow what the court says. It's very important for counsel, and one reason I mention this is that I've seen so many instances while in the federal prisons where the able defense counsel obviously didn't understand some of these things, such as an expectation that a person would be at a particular prison camp, or at least it wasn't communicated to the client very well. And, the things that you need to do to interact with the Bureau of Prisons that can make a difference in where your client goes or what their circumstances may be are quite substantial. Starters, look at the resources. The administrative law sources for the Federal Bureau of Prisons are first the Code of Federal Regulations. The about half of the CFR volumes involving the Justice Department are Bureau of Prisons regulations. Everything to custody classifications, to grievance procedures, and the internal procedures for disciplinary hearings and the like. So it's all accessible to you. Secondly, the subsidiary regulations under CFR are called program statements. These would be the equivalent of what we called in the military Department of Defense directives or Secretary of the Navy instructions or the like. They have the force of administrative law. The program statements are issued by the Director of the Federal Bureau of Prisons. Those are all accessible on the internet. If you look on the Bureau of Prisons website, and you will find a wealth of information on things that may be very helpful to your client. Probably the single thing that I see that is missed most, or I saw that was missed most by lawyers in their work, was the opportunity for the Bureau of Prisons to reduce a sentence by a full year by admitting an individual into a substance abuse program. All that is needed is some mention in the pre-sentence investigation report or an addendum to it that, and it could be something this simple, that by reason of stress the accused is drinking too much. That is enough of a predicate for the individual to be admitted into the substance abuse problem. It doesn't have to be a cocaine habit. It doesn't have to, I have seen it successfully done even with someone taking too much over-the-counter medications with alcohol in them. Now, it doesn't guarantee admission to the program because that has to be done through the Bureau of Prisons counselors. But there, certainly in the white-collar area, there is often a sincere desire of the Bureau of Prisons staff to be helpful if they have the ability to be. And where possible, if you make sure you have some note in the PSI of whatever you can say about drinking or anything, then you may give your client an opportunity to earn literally a full year reduction in sentence by going through the drug and alcohol program. Yes, Judge Everett.
To what extent is there interaction between the probation officer and the report made by that officer and the Bureau of Prisons in assignment?
It varies between facility. Very typically, if there is some mention in it, in the report, or in an addendum to the report, that's all that's needed. Ordinarily, the probation officers and the Bureau of Prison staff are all so busy that they just don't go behind that. There are times where the drug and alcohol counselor at the particular Bureau of Prisons facility will communicate with the court and ask the court for a recommendation. But again, very often as a counsel, if you can make sure the paperwork's in there, make sure the reference is in there, you don't need more than probably 6 words or 10 words. You can do it.
I'm sorry.
Yes, sir.
I can put in a plug for those of you who have major corporate clients. As a matter of fact, the rate of recidivism is absolutely staggering. Those individuals who have been incarcerated and wind up going back, it's so desperately unnecessary. And in my experience, when I was released from Seymour Johnson, I went to a halfway house. And the experience there just exacerbated my concern for these folks, because as soon as they got out, immediately, if they didn't have a job, then sometimes within 30 days they'd go back or whatever, but having an occupation meant everything. It gave, self-reliance, it gave them more credibility with their family, it gave them so many things that they didn't have to go back on the street for drugs for. I know Judge Horn and I and the probation office in Charlotte worked briefly initially on bringing in employers and giving some of these people an opportunity. You'd be surprised at how outrageously dedicated they are and how badly they want to be reacclimated to real life. Having that job, having an income, provides a whole new life for these people. So please look at that side of it too.
Let me also suggest cordial and extremely careful interaction with the staff of the Bureau of Prisons facility where you have a client. They've had so many bad results with lawyers that they're often wary, but approached with kindness, they will relax and do much to help you. Judge Everett and I were out at Butner with 38 of the Duke Law students 2 weeks ago. One of the things that I now am able to do is be something of a tour director in taking law students back where I used to be locked up. And I have been blessed with credibility with the staff there and cooperation, and we get tremendous insight for the students into the things we're talking about now, which I think is going to be helpful to them in the future. But as we met with the warden after the tour this last time, she sat next to me and said, Mr. Tom said, you can understand better than many people why our men need jobs and need training. And she said, we have no life prisoners here. Everyone's going home. And it's a question of what will they do when they get there? Will they come back? Will they have to be warehoused at great expense? Or will they be able to live in free society? So I would make a plug for you to, as you're working with Bureau of Prisons people, be the kind of lawyer that they can relax with that much as they do with Judge Everett, and ask for his help and advice to do their job better. Because for the most part, almost entirely, these people are very, very concerned about trying to do the right thing, trying to help the men do the right thing. And if they're given any help and encouragement, they're very appreciative. Thank you for the time today.
We're gonna adjourn to the Birdman Lounge, which is, you just go out and go down this hall and take a right for a reception. I'm sure the speakers will be delighted to answer your questions. Sorry, I kept somebody else back there.
All right, I'll do it.
Thank you very much for joining us. You get a chance to see Doris Kelly, who works for Judge Everett. Please thank her for her good work.